and 2 appeals filed by Rosemary Fitzgerald pertaining to issuance of building permits 20-098 and 21-004, both of which were issued by the Orono Code Enforcement Officer. So to begin, and there's a few things that we need to go through just procedurally, but to begin with, I'm going to take attendance. We'll start with Bill DeVoe, who has recused himself from tonight's hearing, so he is not in attendance. Shane Martin.
Here.
Gary Noyes.
Here.
Paula Moore.
Here.
Paul Smith.
Present.
Mary Cathcart.
Here.
And Jennifer Jane.
Here.
All right, let's move to the second item on the agenda, which is the election of a vice chairperson. We need a vice chair in order to move forward this evening. But as I said, I'm glad to help that vice chair and sort of play the role as conductor. But there are things that a chair needs to do that I cannot do as counsel. So I guess I would open the floor up to a nomination for an interim chair or a chair pro tem for this evening.
I nominate Shane Martin.
I nominate Mary Cathcart.
Oh, shit. Oh no, we have competition.
So,
I would recuse myself and say, no, I don't want to serve as chair. Thank you.
we have
I'll second the nomination of Shane Martin.
well, you will second the motion.
Yes, thank you.
All right. Is there any discussion regarding the nomination of Shane Martin as tonight's or as the chair, interim chair for this evening's hearings? All right. Because we are Zoom, it's a little bit awkward, but electronic hearings require that we actually take a voice vote. So we'll begin with Gary Noyes.
Yes.
Paula Moores.
Yes.
Paul Smith.
Yes.
Mary Cathcart.
Yes.
Jennifer Jane.
Yes.
Shane Martin.
Yes.
Yay.
Congratulations,
Thank you,
Shane.
Yay.
All right, and I'm hoping that everyone can hear me, everybody that's not on my visual screen. But before we get underway tonight, I need to ask anyone who intends to offer testimony this evening to please raise their right hand and be sworn. Do you solemnly swear in the matter on this hearing to tell the truth, the whole truth, and nothing but the truth, so help you God? When I get back in, I'm going to take a list of those individuals that took said oath so that I can record that for the record. All right, Sophie, it might be helpful at this point if we had, the board doesn't need to be on the screen, I don't think, but it would be helpful if we had Attorney Foster and Attorney Lyons on the screen. Good morning, good evening, good evening. Just the parties have agreed, based on earlier conversations, that the 2 pending appeals of building permit 20-98 and building permit, or should be consolidated into one appeal, and the 2 appeals of building permit 21-004 should be consolidated into a single appeal. And my question for both of you is, just for the record, no objection to that structure?
No objection. Both parties are now represented by Reverend Winchell and myself.
Same with you, Patrick?
No objections. Thank you.
So I guess my recommendation is that we consider the appeal of building permit 2098 first. Then at the conclusion of that appeal, we simply incorporate the record, the testimony, the evidence, and the findings from that appeal into the appeal of building permit 21004. There's going to be a lot of crossover information. It doesn't make sense to do the same thing twice. I think we can incorporate that information from the first appeal into the second appeal. It should keep things moving smoothly and cut down substantially on our time. With all that said, unless there's any objection, Shane Martin, as you heard, has been elected to be our interim chair for this evening. Would you like to call the meeting to order, Shane? The hearing, would you like to call the hearing on the administrative appeal of building permit 20-98 to order? Shane, you are muted. You are muted.
Muted. Okay, I'm muted. All right. Well, I like to keep myself muted. That way, extraneous noise doesn't come out. The meeting for the appeal for building permit 20-098 of the Orono Board of Appeals is hereby called to order.
Okay. Step one is to determine that there's a quorum. Under the Orono Code, a majority of the full voting membership of the board shall constitute a quorum for purposes of deciding an appeal. In our case, that's four members. Obviously, we have more than 4 members present. Unless there's some objection, it appears that we have a quorum. Step 2 is to describe the record on appeal. I am the scrivener for tonight. I will likely be writing the decision for the board. So I've been the keeper and the compiler of the record on appeal. And at this point, what I have as the record on appeal are the appeals that were filed by Dana and Kelly Watts of building permits 2098 and 2104. The appeals that were filed by Rosemary Fitzgerald of building permit 2098 and 2104. I have all the pre-filed documentary evidence filed by the parties and the code enforcement officer. And then to the extent we receive any additional evidence tonight that is accepted by the board during the course of the hearings, those will likewise be included in the record. I received a couple of items from Attorney Foster today. We'll wait till you present those, and if the board accepts them, we'll include those in the record as well. Step 3, as you know from your training, is to determine whether this board has jurisdiction over these appeals. Based on the record, building permit 2098 was issued on June 30th, 2020, and building permit 2104 was issued on July 8th, 2020. Under the Orono Code, appeals must be filed within 30 days of the official written decision appealed from. In this case, that date is July 30th for permit 2098 and August 7th for building permit 2104. The Watts appeal of the 2 permits, 2098 and 2104, were both filed on July 27th, 2020. And the Fitzgerald appeal of building permit 2098 and 2104 were both filed on July 30th, 2020. All of those appeals filed within the 30-day deadline. So I would entertain a motion that based on the evidence in the record on appeal, that the Board of Appeals has jurisdiction to entertain both of the appeals of the building permit 2098 and both appeals of building permit 21004. Is anyone willing to make that motion as stated?
So moved.
Second,
Who seconded?
Noise.
Gary Noyes. George Noyes. Any discussion? All right. Again, it's electronic format, so I need to take a voice vote. Shane Martin,
Affirmative.
Gary Noyes,
Yes.
Paula Moore,
Affirmative.
Paul Smith,
Yes.
Mary Cathcart,
Yes,
and Jennifer Jane.
Yes.
Jennifer, am I pronouncing that name right?
Yes.
Good, thank you. All right. The next step is to decide whether the applicants, the Wattses and Ms. Fitzgerald, have standing or a right to appear before this board. Based on the evidence, the property benefited by the two building permits is located at 163 Gould Road in Orono and is owned by Joseph. How do we pronounce Joseph's name? Is it Sprecher? Sprecher.
Sprecher.
Sprecher. And Mindy Merrill. The Watts own property located at 167 Gould Road. Ms. Fitzgerald owns property located at 157 Gould Road. Both of these properties, the Watts property and the Fitzgerald property, are located immediately adjacent to the Sprecher property. And as such, they are abutters, and under the law, they are, as abutters, they have legal standing to appeal the building permits that were issued. But with that said, again, I would entertain a motion that the Board of Appeals has jurisdiction to entertain both the Watts appeal and the Fitzgerald appeal of building permit 2098.
So moved.
second,
Who seconded?
Catherine.
I can't look that fast. Any discussion? Roll call. Shane Martin,
Yes.
Gary Noyes,
Yes.
Paula Moore,
Yes.
Paul Smith,
Yes.
Mary Cathcart,
Yes,
Jennifer Jane.
Yes.
All right. All right. That's kind of the preliminary stuff. So again, I know this board is new, relatively new. We're on Zoom. I know we have a lot of people sort of waiting in the wings, listening in, that are interested in these proceedings. I thought it would be helpful, and I thought in the long run it might save us all a bit of time if I went through sort of the ground rules, what was expected, what was actually pending before the board this evening, and so that everybody knows exactly what to expect. So what we've thought is that we would have very brief, or offer an opportunity for very brief opening statements by Katie Foster, Attorney Foster, and Attorney Lyons, to sort of help set the stage for tonight's proceeding and to give some context, larger context for their presentations. The code enforcement officer, if he is so desirous, is also welcome to say a few words. Then Mr. and Mrs. Watts and Mrs. Fitzgerald, who are all represented by Attorney Foster, will present their case without interruption. When I say without interruption, I still think the board can ask questions, clarification questions during the presentation, but it's always nice to give the party an opportunity to speak uninterrupted. At the end of Attorney Foster's presentation, the board can offer an opportunity for others to ask questions through our chair. Then the Spreckers will be given an opportunity to present their case uninterrupted. Again, the board can ask for clarification. If they have questions requiring clarification during the presentation, I think go ahead and ask them. But again, it's nice to give the party an uninterrupted chance to make their case. All parties will be given an opportunity to refute or rebut statements that are made throughout the hearing. The code enforcement officer, who is not really a party to this case, is available through David Myland. David Myland is the director of planning. He is 80K certified. He is knowledgeable about these building permits, and questions for the CEO can be directed through David or through Mr. Myland if necessary. The hearing will be closed after everybody's been given a reasonable opportunity to be heard. And hopefully this isn't the case, but if we need additional time, the hearing can always be continued to a later date. Again, hopefully that will not be necessary. With regards to evidence, the technical rules of evidence do not apply here. The board is encouraged to accept all evidence if it's of the kind of evidence upon which reasonable persons are accustomed to rely in the conduct of serious affairs. It's a pretty easy standard to apply. The board should exclude irrelevant, immaterial, or unduly repetitious information, and to that extent, the chair has the authority and the power to sort of control those presentations. If things are starting to get off track, you can certainly bring them back onto track for everyone. If you do present evidence tonight, because I'm the keeper of the record, it would be nice if you emailed it to me tonight or tomorrow morning so that I can include that in the record on appeals. All right. Let me just say a few words about the sort of the scope of tonight's hearing, the burden of proof, and the standard of review.
For a sec,
What's that?
can I add a brief comment for a sec? I was going to mention this earlier, but it passed. I don't know how long this meeting is going to run and the flow, but at some point in the flow of it, if you think it's an appropriate time to take a recess for people to go to the bathroom and such, I would suggest you offer that at some point. If we get to the 2 or 3 hour point, or hour and a half, 2 hours, which I'm sure we'll reach, that may be good.
Well, that's the power that you have, Mr. Chair. Whenever you deem that appropriate, you can make that call.
But just keep that in mind. Just
Okay.
when you feel that maybe it's a good, I don't want to interrupt the flow of things, but.
Okay, so as far as the scope of this hearing, you received a tremendous amount of information, good information, cogent information, but let's just to sort of focus in on the scope of this board's authority, and the attorneys certainly can take me to task during their presentations if they think I get it wrong. But with respect to building permit 2098, the permit allows for 5 things. The depositing 15 to 20 yards of fill to the shorefront lot, earthwork to repair a retaining wall, the addition of a replacement windows on the 4th floor, install 2 skylights on 2nd floor, and install sliding patio door on 2nd story with egress landing to stairs to grade. That's a description, that's what's stated on the permit application. And that is what approval was given for when the code officer granted the building permits. The question before this board is, based on the evidence that's been presented to you already and that you hear this evening, should these permits have been issued? Should these issues have been issued? So should these permits have been issued, this permit been issued for those items based on the evidence that has been presented already and that will be presented this evening? It is not relevant as to what information the code enforcement officer had or the decision that the code enforcement officer made. Your review, as we talked about during training, is de novo. You start with no record. You start with no, you're not reviewing the code officer's decision. You are making your own decision based on the evidence presented to you. Again, that question is, should the permit have been issued for those activities based on the evidence presented to you? Whether Mr., and this is where it gets a little tricky, whether Mr. Sprecher complied with those permits or whether he has done work on his property without permits is not before the board this evening. Those are enforcement questions that are not appealable to the Board of Appeals. Does that make sense? Okay,
Could
so,
you reiterate that again?
okay, it's whether we're talking about whether these permits should have been issued in the first instance. Whether he complied with those permits after they were issued, or whether he did things on his property that should have triggered the need for a permit, are not at issue tonight. Those are enforcement questions that are not within this board's jurisdiction based on your code of ordinances in Orono. It specifically says enforcement decisions are not appealable to this board. So to the extent that we can keep focused on the enforcement issues aside, I think we will save some time, so I think things will go much more smoothly. The code also requires that the appellants, in this case, the Wattses and Mrs. Fitzgerald are the appellants, and they have the burden to demonstrate that the permits should not have been issued. If they don't carry that burden, then the permits must stand.
Roger, I have a question about that. Because it's a de novo review, the burden wouldn't be on the material submitted before the board?
It is, I am reading from the code. It says, in administrative appeals, the burden rests with the appellant throughout the proceeding.
Understood, just checking.
I understand the question, but that's what the code says. Another thing, it might be useful, and I direct this to the board, but hopefully the appellants are listening. It might be useful at some point for the appellants to tell the board which activities under building permit 2098 are that the appellants believe the CEO approved in error. I count 5 activities that for which approval was sought. I think the code enforcement officer granted the permit, so I think all 5 of those activities were approved. To the extent that you don't challenge some of those activities, and it's totally up to you, obviously, what you do. But to the extent you don't challenge those activities, it might be helpful in sort of narrowing the scope of tonight's hearing. Decision-making. Once the evidence has been presented, both parties, everybody's had a chance to cross-examine. and say their piece. The interim chair will close the public hearing and deliberations will begin. The board has, under the code allows that the board has the power, or the action of the code enforcement officer, quote, may be approved, modified, or reversed by the Board of Appeals. Once a vote is taken, I will need to understand why the board did what it did, obviously. And I may poll the board as to your individual viewpoints as to why you voted the way that you did, so that I can write a thorough decision. I will, once the hearing's over, I will take the information, the vote. Once the hearing's over, vote is taken. I'm satisfied that I understand why all of you did what you did, both collectively and as individuals. I will take that information, go back to my office. I will write a decision. This hearing will be continued to give me a chance to write that decision, and then we will, the hearing will be continued. We'll reopen the hearing in a week or two to allow the board to consider the written decision and to make changes. And I would add that under the code and under the vote that I would have the board take this evening, the decision is not final until the board votes and issues its written decision. So with that very long-winded description of where we're going, I think we start going. Attorney Foster, would you like to make a few brief opening statements, set some context for tonight?
Sure. So just to clarify, we've only been introduced to the first permit. So do you only want opening statements as they apply to the first permit and just provide general context? Or do you just want me to give opening statements and then we'll go into the hearing process?
Yes, to some extent, it's an artificial to
I'll just
separate
go
these two.
from a high level, talk about everything,
We're
and then
gonna
we can narrow down.
Yeah, we're going to incorporate whatever you say into the next hearing anyway. So I think if you bleed over into the second building permit, I don't think that's going to be an issue.
Understood. Okay, I'll get started. Good evening to the Town of Orono Board of Appeals. My name is Katie Foster, and I'm an attorney for Rosemary Fitzgerald, Kelly Watts, and Dana Watts, as you have been introduced this evening. It was our hope that we would be on a big screen here in our office, but here with me tonight, because of our technical difficulties, are my colleague, attorney Mike Hockenberry, and our client, Rosemary Fitzgerald, as well as her partner, Larry. Dana Watts and Kelly Watts have joined us virtually. Rosemary Fitzgerald has been coming to Orono and enjoying her property on Pushaw Lake for nearly 85 years. Yes, that seems like a long time, but she is 84 years old and the property has been in her family for that time. She is well regarded and well respected in the community and as a friend to the University of Maine and to all of her neighbors. Mr. and Mrs. Watts have been coming to Orono for nearly 30 years and have owned the property abutting the Sprecher property for 15. Attorney Lyons is correct when he says that the two neighbors are friends, as they have enjoyed peaceful coexistence and friendship with each other and with their neighbors along Gould Road. The history of litigation between the Sprechers and our client Rosemary is immaterial to the matters before you tonight. The efforts to paint Rosemary as vindictive, meddling, and an out-of-town neighbor filing petty appeals as a means of advocacy is noise and conjecture that is meant to distract from the issues. We would ask that Attorney Lyons and others testifying tonight refrain from any additional comments regarding Ms. Fitzgerald's character, as they are irrelevant to analyzing whether the applicable law has been complied with. I will briefly highlight the primary issues that will be discussed in greater detail during the individual hearings this evening. First, the Fitzgerald Watts exhibits show that there are two different types of rock structure on the shorefront parcel. The old foundation is a type of mortared stone, and then there is a rock wall that could not possibly have supported a structure. No evidence has been submitted to establish the pre-existing size, width, or extent of the retaining wall. Further, the application seeks approval to complete earthwork to repair the retaining wall, but not to actually repair the retaining wall. The record includes no evidence to establish the work completed, or the distance between the existing retaining wall and the water body, or any explanation of what was done here, or whether what we are seeing is in fact an expansion of a non-conforming structure. The Watts property has seen more collected debris on the shorefront this summer than ever before in 15 years. There is no evidence that the debris is not the result of accelerated erosion and pollution from the extensive work that is being done on the property next door. While the Spretchers allege that they spoke with Mr. Murphy about erosion control, there is no evidence of these conversations in the record. We will offer testimony from our client, Dana Watts, about his observation of the clearing, groundwork, and earth moving that was completed in May 2020. By adding a second-story set of stairs and landing, a non-conforming structure will be expanded, but there is no evidence that the requested expansion will comply with the provisions of the ordinance regarding non-conformity. There is no evidence except statements from Mr. Sprecher that this new addition is required for ingress and egress, or that the structure has not already been expanded to the 30% limit. That's just the first permit. As to the second permit, the back lots were fully wooded parcels prior to Mr. Sprecher's ownership. The parcels were cleared extensively, as shown in many exhibits that we will present this evening. The hand-drawn site plan that has been put forth as evidence for the parking area is inadequate, misleading, and not to scale. The high water line from which we are measuring 250 feet to establish the parking area is outside the shoreland zone is a plan that with a squiggle blue line where Mr. Sprecher has added his own high water line, not clearly delineated or marked on the plan by a professional land surveyor. However, using Mr. Sprecher's own map and measurement, we were able to measure from the high water line of his shorefront parcel, and it is abundantly clear that a portion of this parking area is in the shoreland zone. The portions of the backlots in the shoreland zone require a permit from the planning board for a parking area, of which he has not obtained. The misrepresentations and misdirection and misleading statements that are present in this record present a significant potential damage to Pushaw Lake. The increased likelihood of water pollution, accelerated erosion, and the lasting and irreversible impact of this development is something that you should strongly consider when evaluating the record before you. Our request is simple and straightforward. The Spretchers be required to comply with the law. The record evidence does not establish that the land use ordinance, shoreline zoning ordinance, and applicable law has been complied with, and therefore these applications must be denied. Thank you.
Attorney Lyons?
Thank you. Good evening. My name is Patrick Lyons. I'm an attorney with the law firm Eaton Peabody. The buildings, and I represent Joe Sprecher and Mindy Merrill. The building permits granted to Joe and Mindy are for simple activities: to shore up a deteriorating retaining wall, needed improvements to a house purchased at a foreclosure, and the cutting of some trees and the spreading of gravel for a residential parking area. What has been made things not so simple is that Joe and Mindy are budding longtime summer homeowners that do not like change to the neighborhood. Joe and Mindy recently brought their two families and combined 5 children together for the first time in their new year-round home on Pushaw Lake. And they started making changes that are in their rights and necessary for the safe use and enjoyment of their home. Further complicating the situation is Ms. Fitzgerald's continued interference with Joe and Mindy's ability to access a large portion of their property. Upon moving into their new home, Joe and Mindy were welcomed by fencing that has recently been installed by Ms. Fitzgerald along the back lots, blocking access to their property. Approximately 60 feet of that fence is actually on Joe and Mindy's land. Despite numerous attempts by Joe and Mindy to amicably resolve this issue with their new neighbor, Ms. Fitzgerald refused to remove her fencing. While I'll not go into detail here, Ms. Fitzgerald has been anything but neighborly to Joe and Mindy. While no one wants to bring a lawsuit against their neighbor, Ms. Fitzgerald's actions left Joe and Mindy without any recourse. The lawsuit is still pending. As Attorney Foster agrees, it is also not relevant to your determination here tonight. However, this appeal is nothing but a continuation of Ms. Fitzgerald's relentless interference with Joe and Mindy's property rights. As detailed in our filings to the board, and as will be shown tonight, the evidence before CEO Murphy was substantial and satisfied the requirements for building permit applications sought by Joe and Mindy. Indeed, Joe and Mindy communicated frequently with CEO Murphy and John Cullen of the DEP to ensure compliance with all applicable state and local laws and ordinances. The Board of Appeals should deny the appeals and uphold Joe and Mindy's permits as they have satisfied the burden of proving the proposed land uses activities conform with all applicable provisions with Orono's ordinances. Thank you.
Mr. Mylan, do you want to say anything? You certainly don't need to, but the option is yours.
Good evening, folks. My name is Dave Mylan, and I am the Director of Economic Community Development for Town of Orono, and I oversee the Office of Code Enforcement. Bill Murphy is our Code Enforcement Officer and is with me tonight. And we certainly are here to answer any questions that the board may have as you go forward tonight. I think the only point I wanted to share with you at the beginning, Roger, and to others, is that though this is not a review of Bill's, the code enforcement officer's work, you as lay people are trying to decide whether a permit should have been given out. You may, as this goes through this evening, you may have questions and not being a code enforcement officer yourself, you may have questions that, what a code enforcement officer looks at a particular issue as he or she is deciding a permit. Please feel free to ask those questions, and we're happy to provide the answers to those as the best of our ability. Thank you.
Thanks, David. With that said, board, any concerns before we move forward? All right. Attorney Foster, I think it's your show for a while.
Trying to unmute myself with my left hand. Okay, so we're going to get started, and I think probably what we will want to do before we get started is narrow down, as Attorney Huber said, we may want to do the issues in the first building permit. So the issues that we are currently going to speak about are the 15 to 20 yards of fill that were added, the earthwork to repair retaining wall, and the second story patio landing with stairs to grade. The other items, they don't really matter. We don't really feel that there has been a significant egregious lack of information about what they plan to do there. They want to put some skylights in. It's a pretty clear thing. So we're not challenging those.
To clarify, you're not challenging the window replacement on 4th floor either, or are you?
No, we're not. I was just giving an example. So no challenge to the window replacement on the 4th floor. That's correct. The challenge that we would like to have be heard on this evening is to the fill that's being brought into the shorefront parcel, the earthwork to repair the retaining wall, and the second story patio landing.
Thank you. That's helpful.
You're welcome. As a threshold matter, the principal structure that's located on the shorefront parcel is a non-conforming structure. So while we understand that landowners want to have the rights to do certain work on their property, there are certain limitations in your ordinance that must be complied with because this is a shorefront parcel. So in addition to being subject to the land use ordinance, the applicants were required to comply with the shoreland zoning ordinance. It is a huge concern that there has been a significant amount of fill brought into this parcel without soil and an erosion and sedimentation control plan being submitted. It's not sufficient evidence to establish that erosion and sedimentation control measures have been taken on this parcel to simply say in the permit that, note, erosion and sedimentation control will be complied with. There is no information from which someone can look and say what has been done for erosion and sedimentation control. There's been nothing submitted in writing to say this is what we're going to do to account for additional soil that may be packed down or run off, or what we're going to do if there becomes additional water flow or storm water running from the top of the hill. And as you can tell from the exhibits, there's a significant opportunity for stormwater runoff to come from the road down into the resource. So our clients are very concerned about the fill and the lack of erosion and sedimentation control. This is not in compliance with the shoreline zoning ordinance. As you've seen from our submission, if you are to bring in fill on the shorefront, earthwork to repair the retaining wall, and bringing in 15 to 20 cubic yards of fill requires that an erosion and sedimentation control plan be submitted in accordance with section 18-274-16. There is no record evidence of that submission. There's nothing to suggest that was even contemplated or complied with. Period. The application also lacks information on the soils that are on the property and whether or not those are permeable soils. So does the water sink into that? Does it flow into the resource? We don't know the answer to that because there's been no information submitted on that. The ordinance also requires in section 18-274-17 that all land uses should be located on soils in or upon which the proposed use or structures can be established. Is she waving? Oh no. Can be established or maintained without causing adverse environmental impacts, including severe erosion, mass soil movement, improper drainage, and water pollution, whether during or after construction. There is no evidence before you tonight that establishes whether during or after construction on this parcel, there was improper drainage, water pollution, or mass soil movement. Due to the topography of the shorefront parcel and the significant potential for water pollution and accelerated erosion, it is critical that the applicable erosion and sedimentation control provisions and soil provisions be complied with. So that is our primary concern with the filling on the shorefront parcel. So this is kind of hard because I can't really read your body language, so I'm going to continue moving through this, but if you have any questions, feel free to interrupt. So as you can probably tell from the submission of our materials, we have significant questions about the retaining wall that's been alleged to exist on this property. As you saw from the materials that were submitted by Attorney Lyons, they have had their surveyor update the plan to include the outline of an old foundation that was on a 1990 sketch of Mr. Brian Thompson, the former owner. Our concerns with that is that there is not sufficient or credible evidence to establish what is on the property today. And one of the exhibits that Roger mentioned, Attorney Huber, sorry, is after receiving the package from Attorney Lyons, I reached out to Surveyor Julian Wiggins and just wanted to try to get some more information on why this was added and what had happened when he first visited the property and why he had chosen not to include this retaining wall during his first visit. I thought that there was significant questions given that in other areas of the survey. I think you have it before you as Exhibit A. You can see that there are retaining walls delineated on the Sprecher parcel. So we had questions. What's going on here? Where's this retaining wall? Where did it exist before? All things that should have been delineated on a site plan and were not included. So Julian Wiggins wrote back to me, and Roger has a copy of this email, and Attorney Lyons was copied on the email as well, so I know that he's aware of it. And he said, I can confirm that I've produced an updated plan of the parcel on Gould Road. I have added the building foundation to the plan with a note stating that it is approximate and that the location is based on the MLI sketch produced by Jeffrey Rice. This is the 1990 sketch that's included in your materials as Exhibit C. He said, I did so as I do recall the old foundation being there, although after reviewing my data collected on site, I had not located the extent of the foundation while on site. I would not rely on the exact dimensions or the exact location based on the MLI. However, I can confirm that a stone foundation did indeed exist in the approximate location. So this is concerning for a couple of reasons, because for purposes of understanding whether a non-conforming structure has been expanded, we need to know what the exact location is, what the height, width, and diameter, how close it is to the water body, and whether it's gotten closer. Because if it has gotten closer, that's a violation, and we will need to follow up on that. And the Town of Orono permit application procedure requires the following submissions in section 1862B. It says, there shall be submitted with all applications a layout or plot plan drawn to scale showing the location and size of all buildings, structures, and other significant features currently existing on the lot in all areas subject to shoreland zoning, shoreland setbacks, water bodies, and wetlands within 250 feet of the property boundary. The exact size and location on the lot of the buildings, structures, and accessory buildings to be erected, and such information as may be necessary to determine and provide for the enforcement of the LUO. The existing and intended use of each building or structure. Where applicable, the location of soil test pits, subsurface sewage disposal systems, site drainage, parking lots, driveways, signs, etc. The concern is that the submission requirements at the outset were not complied with. The site plan that's included doesn't show a retaining wall that's a square, that's an old foundation. It shows a dotted line of tiny little circles drawn on the plan with no indication of how big that structure is. We don't challenge Mr. Wiggins' determination that there may have been some portions of an old foundation on this property. And you'll see in the exhibits that we submitted, exhibit D through D2. I don't know if you have those before you. Attorney Lyons also submitted the same images as part of his package, so you may have them twice. That there are two different types of rock structure here. So we would argue that the mortared stone that you see in the right-hand side is probably and likely part of the old foundation. However, what you will also see is a newly extended rock wall that doesn't have any vegetation in or around it. You can kind of see that there's a little bit of grass poking up, but it looks like baby grass that it just came in the last couple months. So we have a lot of questions about when the significant amount of vegetation that you'll see in our exhibit B, which is the listing photo of the property, which shows it's highly vegetated, when all of that was removed. So if this was submitted as the existing photo to establish what existed when Mr. Sprecher applied for his permits, what happened to all the vegetation, what's existing. And so part of our concern with the permits is that there's no evidence in the record to definitively establish the starting point. We feel that there's an alternate reality being created here and a starting point that we're not comfortable with. And we can't tell from what's been submitted about the retaining wall whether the land use ordinance and the shoreline zoning ordinance is being complied with. Are there any questions about that? Roger, do you want us to take questions?
Whatever you would like.
I'm fine taking questions. I don't want to just keep talking. If people have questions, I'm going to kind of move through the issues, but if anyone has questions, you can feel free to interrupt me. I have no problem with you interrupting the flow or anything like that.
Mr. Chair, Shane, may I ask a question?
Sure.
Thank you. So you're saying because of the shoreline zoning ordinance and the possibility of the soil erosion, the runoff, the type of soil, that this, instead of the code enforcement being able to issue the permit, it should have been sent to the planning board for
Not in this instance. The code enforcement officer could have issued a permit here if the evidence was submitted regarding the soil and the erosion and sedimentation control plan and the soils, because he would have had the information before him to determine whether or not the ordinance was being complied with. That's what we're saying. Does that make sense?
Yeah, thank you very much.
Yeah, so more to that point, if you all had an erosion and sedimentation control plan as part of the record evidence before you, you would be able to look at that and say, okay, now we understand what they intend to do, what they intend to install for erosion control measures, and we would be able to say with certainty that the water body wouldn't be impacted by the work that's being done. Because none of that information is in the record, we can't say whether or not there's going to be an impact to the water body. We don't know what water pollution may occur because of this work. And because this is a shoreland parcel, those items are required in order to get these permits.
Thank you.
Attorney Foster, may I ask, and just to make sure that we're all clear, again, we're looking at what evidence we have before us now.
Right, and what I'm saying is that
it's your argument that information isn't in the record before us. You would agree that it really doesn't matter what information was presented to the code enforcement officer.
I'm arguing that it also has not been presented to you all because there's additional information in the record before you tonight that was not submitted to the code officer that's been submitted as part of this record. So my argument would be that because of the lack of information in this record, there is not sufficient information to rely upon to grant these permits
Okay.
because of what's in the record, not because of what was presented to the code officer. It doesn't really matter what was presented to the code officer, but what was presented as part of the applications in this matter is part of this record. And the record is deficient in many areas.
Understood. Understood. Okay. Thank
Is
you.
that in line with what you think?
Yeah, I mean, I just want to make sure that, I mean, the one thing that we all agree on is that the board's authority is de novo, that it needs to make a determination as to whether these permits should issue based on the information presented to this board, not what was presented to the code officer. But what I hear you saying is you're just referencing the material that was presented to the code officer. That's part of this record for sure.
Yes.
Yeah, okay.
So Chair Martin, may I ask a question?
Sure.
So either of the attorneys, I'm unclear whether or not the DEP, Mr. Cullen's information is something we should consider. I mean, because,
So it would be,
sorry.
okay. If you need clarification, feel free to ask me again. So Mr. Cullen, it is our position that there have been some misrepresentations made about Mr. Cullen's position on this property, about what's happening on this property. And another thing that I sent to Roger today was an email that I sent to John, that John Cullen sent to Attorney Patrick Lyons and copied me on. And so part of the presentation submitted by Attorney Lyons on behalf of Mr. Sprecher and Ms. Merrill said that John Cullen's position was that this property was in compliance. I would first suggest that the permit before the DEP was for replacement of the retaining wall. That's not what the local permit requested. What was requested in your permit was earthwork to repair a retaining wall. So it's kind of a nuanced issue, but it's not asking for the same thing, if that makes sense. So whether or not the permit from DEP is in compliance based on what DEP thinks about it, it doesn't really matter for purposes of whether your local ordinances have been complied with, because they're asking for different things. Additionally, Mr. Cullen responded on Wednesday, August 19th, which was this Wednesday, and he said, Mr. Lyons, just a quick follow-up to our conversation last week regarding the Sprecher property on Gould Road in Orono. As we discussed, the issue of whether or not the work that has been done to this point on the retaining wall is in compliance with the permit by rule has not yet been fully determined. If the wall is the same height and no closer to the lake, then yes, I would consider that portion of the project to be in compliance. I hope this clarifies the DEP's position. Let me know if I can be of further assistance. So some of the threshold questions that you're being asked to consider as part of whether or not there's enough evidence in this record to establish whether this is in compliance, like how high was it when it started? Is it any higher? Or is it closer to the water body? Well, we don't really know because there's not enough evidence in our record to establish what the pre-existing conditions were. And Mr. Cullen's asking some of those same questions. He will have to make his own determination because the DEP permit is separate.
Thank you.
You're welcome. So moving on to my third and final issue for this matter, the principal structure that's located on the shorefront parcel, the home where these folks are year-round residents, this is a non-conforming structure. And what that means is that it does not meet one or more of the following, sorry about that, dimensional requirements, setback, height, or lot coverage, but it is allowed because it took lawful existence before the land use ordinance came into effect. And in this instance, it is likely that the prior structure that was on this parcel, the small camp that was very close to the water, was allowed to be moved back and rebuilt because it had been there for a really long time. So I don't know the details of how that procedure went, but there was a non-conforming structure on that property and it was moved back. A non-conforming structure may not be added to or expanded, or it could be if it doesn't increase the non-conformity of the structure and if it's in accordance with certain provisions of your land use ordinance. And those are articulated in section 18.303. In this instance, the addition of a second-story stair and landing would expand the non-conforming structure. We have not seen any evidence in the record that an analysis was done to determine whether this was required or necessary for ingress and egress. There are statements from the property owners that it is necessary, that they need this, but there's nothing from a fire chief or a life safety professional that says, yes, we really need you to add that to the structure so that you can safely come in and out of the structure. Frankly, there are other areas that would suggest that there's a second story landing already on the property, as you can see in some of the exhibits. And the permit does not include the required analysis of whether subsections 1 and 2 have been complied with. One of the provisions that's particularly relevant is that after January 1st, 1989, if any portion of a structure is less than the required setback from the normal high water line of a water body or tributary stream, or the upland edge of a wetland, that portion of the structure shall not be expanded as measured in floor area or volume by 30% or more during the lifetime of the structure. So that's not saying that you can expand it 30% and the next owner can expand it 30%. That's saying in the lifetime of the structure, it can't be expanded by 30% or more. We have no evidence in the record to establish whether or not this structure has already maxed itself out, basically. We don't know, based on what we have before us, whether they are entitled to this expansion or whether it will put them to 35 or 40 or 50% over what they're entitled to. Additionally, the total footprint of all structures, parking lots, and other non-vegetative services within the shoreline zone shall not exceed 20% of the lot or portion thereof located within the shoreline zone, including land area previously developed. This is in the Shoreline Zoning Ordinance, Section 18-274-2D. It's referenced in my materials on page 3. And none of this analysis establishes for us what exactly is happening with this structure. It's a 4-story, very large home. And we have no ideas of how big it is, how tall it is, how wide it is, or whether or not this expansion is going to further increase the nonconformity in a way that's not necessary. Are there any questions about that?
Yes, I have a question.
Sure.
If it's a 4-story building and they want to put skylights in the second story, where's the second story come in as opposed to the 4-story?
I don't know the answer to that. You can see in the pictures, if you look at Exhibit B from our materials, it looks like maybe there's like a, here, thanks Rosemary. You can see here that it looks like there's this story, 1, 2, and then there's maybe this story and this story. So I don't know if they intend to include skylights kind of like on this roof structure here.
Okay.
I don't know, because we don't really take issue with that. We just think that this is already a very, very large structure that's taking up a significant portion of this lot. It's a non-conforming structure already. And we just want to be sure that the nonconformity provisions of the ordinance are being strictly complied with. And there's no evidence in the record that they've even been evaluated or an analysis has been completed in this instance.
Okay, thank you.
So that essentially wraps up my preliminary comments. I would like to give an opportunity for Dana Watts, who is on the call, to be included in this portion of it. He is going to provide some testimony about his observations of what's been happening based on living right next door, being there all summer. One of our concerns is that a significant amount of vegetation has been removed from this site and that a significant amount of work has been done as a means to establish that it was done as part of these permitting procedures or in connection with permitted work. And we would argue as part of our presentation that there's no evidence that any of this work has been required or that it is permitted. So I'll turn the floor over to Dana for some brief comments.
Roger, I'd like to object to your comments at the beginning of this. You know, we're not discussing what work has done or has not been done. We're purely, it's a narrow scope of review as to whether the permit should have been issued. So this is all irrelevant, tangential information that is not germane to the board's review of whether the permits should be issued.
Dana Watts intends to offer some testimony about the earthwork that was happening on this site, and now as an attempt to establish an existing condition from which to issue a permit, I think it's very germane to this issue that the existing condition that's being presented as record evidence is not actually the pre-existing condition from which we should be deciding this matter. And evidence that establishes that in the record is, in my opinion, very important to the issue of whether or not these permits should be issued.
That seems to me as being different from whether he had a permit to cut those trees.
I didn't suggest that he didn't have a permit to cut the trees or not. I was just suggesting that Dana Watts is going to offer some testimony about his observations of what was occurring on the property in furtherance of potentially
I'm just trying to keep us out of the enforcement issues, but to the extent your argument is that the current state of the property isn't indicative of what it was pre-permit, that may be relevant to the permit issue, but I just want to steer clear of the enforcement issues.
Yeah, so they're not enforcement issues. We're not saying that this should have been enforced differently or or whatever at this stage. Mr. Watts' testimony is not intended to further that point. What we are attempting to establish for this board is that the evidence that's been submitted as pre-existing conditions, the photographs that have been included from a 15-year landowner, are not representative of what was on the property when they were applied for. And that's incredibly relevant to understanding what's been happening on this property in the last 6 months and how this starting point from which you're meant to issue a permit has been altered prior to even applying for a permit.
Bring on Mr. Watts.
Okay, thank you. Thank you, board members. My name is Dana Watts. As they said, I've lived there for 15 years after visiting the lake for 30. I live right next door to the west side of the property. My house and my property is somewhat on a lower slope than the Spreckers. So they're, for drainage purposes, they're on a higher portion of the land. And so we are subservient to the drainage, and we're very worried about that. One of our main concerns is the retaining wall itself. I will tell you that in October of last year, I was at the house to close it up for the winter time, and Mr. Sprecher was jackhammering a structure that was on the back there. What the Thompsons used to have a water fountain, for want of another term, made of rock and mortar, and it was rather quite large. He was jackhammering it, and I was out barbecuing dinner, and he was on a Saturday, and he says, Joe took a break, so I'm sorry about the noise. And I said, hey, you know, you got to do what you got to do. But there, at that time, there was no visible retaining wall to the east of where that large structure was that he was jackhammering. Next, when I came back in May to open up the place, at that point in time, they asked me if they could cut down some trees. They were going to cut down some trees on their property. They have a very narrow piece of land between the house and our property line. And he asked if it was okay if they trimmed some of our limbs, because he was worried about squirrels getting on their roof, when I gave them permission to do that along the property line, but no further. Also at that time, well, let me ask, do you want me to talk about the back lots as well at this point in time, or later?
No.
Later?
We'll talk about those in the next hearing.
Okay, all right. In regards to the retaining wall, if you look at the pictures of the, what they show us there now, it is not what would look like there in October. It is not what it looked like there in May. Between May and when I came back in July, a great deal of work was done, and the plans don't say what needed to be done to repair. If you look at the original photograph that shows the listing, and I wish I had more photographs, but when it shows the listing, you do not see a ledge or a ground and then a wall and exposed and then down to the lake. If there was anything exposed at all, there was some rocks showing up above the soil, not very much, no more than a foot, foot and a half. What there is there now, if you're standing on the lakeside, I would estimate to be in excess of 4 feet and maybe even as much as 5 feet tall. And so what it appears that they are wanting to do, and the plans really don't say with this, but what I assume they're doing is they're trying to build this wall up. And then the house is over here on this side. then fill it in and level it up and bring in the 15 to 20 yards worth of fill on this shoreland lot without any drainage plan, without any plan that it's not going to excessively drain over to my lower property, with no plan whatsoever. And as Ms. Foster said, this summer we've noticed a great deal more of debris and leaves and weeds and stuff in our shoreline that was never there before in the previous 15 years.
I
And
have
we
to
don't.
object to debris washing up on the shore on the lake. This is not relevant to the wall, nor it could be coming from anywhere. I think we're getting very far beyond the scope of the reason for this testimony.
I think the reason for that testimony that's being offered is that without an erosion and sedimentation control plan, we can't be sure that that isn't coming from the work that's happening on the abutting property. And Mr. Watts is just offering his observations of what he's been seeing since this work commenced and since it's been going on. And that seems very relevant to the issue of whether or not there's adequate evidence in the record to protect the shoreland zone here. But I think Mr. Watts has wrapped up his comments.
No, I have not. Thank you.
Oh, okay.
But what I was saying about again about the wall, the plans do not say anything about what to repair. You want to repair a wall, a rock has fallen down, you pick it up and put it back. It has been expanded in height, width, and depth, and now they want to put the fill behind that, which is we object to. I think it's not according to the code. The other thing is regards to the balcony. I urge you to please look at the survey and also look at the photographs. If you look at the front of the house on the east side to the west, you will see there's a landing and stairs. It is almost to the north side. Where they're going to put the door appears to be 20 feet maybe away from that door. They already have an exit on the second floor. They have an exit that goes to the south side. They have an exit that goes to the west side. They have an exit that goes to the east side. They don't need another one, and it's our understanding that my understanding of the law is that they cannot expand any farther closer to the shore, and that's exactly what they want to do, and to that they object with. So those are my, although the other thing too as well, there's been so much work with his Kubota and other vehicles on the east side of their house when they're coming down to bring these rocks and to stack them up and everything else. They practically have a driveway now on the east side of the house that goes all the way down to the lake, which is very compacted. And we're very concerned that it's almost like a sliding board for runoff from the road down to the lake. And that's another one of our concerns. And the only other thing I have to talk about is the back lot, but I will wait for that.
Thank you, Mr. Watt. Go ahead.
Before you get going, let me just advise the board. Attorney Lyons made an objection. This is not a courtroom. His point is well taken. He articulated his objection. He articulated his concern with the statement that Mr. Watts made and the premise for Mr. Watts's comments. It's the board's prerogative, obviously, to give whatever weight they desire to Mr. Watts's comments, and whether that's relevant and the basis for those comments, and I think that's the best way to deal with objections at this point.
Okay, I have a quick question either for Ms. Foster or Mr. Huber. There's been two references to the listing photograph. Is that in the packet that we received? And if so, which exhibit is it? Because it's been referenced twice.
It's Exhibit B in the package that I submitted.
B as in Bravo?
Yes, B as in Bravo. It looks like this, Mr. Martin.
Okay. All right. So that photo doesn't go down to the water, so we don't get a full perspective of the water line all the way up to the house.
Right, and part of our understanding is that this is the only photo that we have from prior to work starting on this parcel for which we don't know what work was done or not done in accordance with any plans. I think that you can clearly see from Exhibit D that there's no vegetation in what is to be understood as a pre-existing photo. So these photos were submitted to establish this is what exists on the property today. But that is not credible evidence of what was there in 2018 when the property was purchased. It's very clear that this isn't the starting point from which we should be determining what to do on this parcel. Does that make sense?
Yes, thank you.
Mr. Chairman, if I may.
Mr. Moran?
My question is probably to Roger for again, from a process, is that from the code enforcement's perspective, do you want us to wait until the very end? Or again, do you want us as part of this two-way conversation throughout the deliberations to respond to how code enforcement actually does things that it may be contrary to what is being proposed or what is being offered for testimony? Where does the code enforcement fit in for you and for the board? Where can we help you answer some of these questions?
I think you fit third. I'm sorry to say.
No, that's fine. Just wanted to understand because I got pages of notes. Thanks.
We have wrapped our comments. We would proceed with the process as you like it to go.
I would ask the board members if there are any questions of Attorney Foster regarding her presentation.
May I speak? If I could summarize, or I'm checking to see if I'm accurate here. It seems that your major issue is that inadequate plans were submitted with portions of the appeal, portions of their permitting, and that the permitting was granted after alterations on the property. Am I accurate there? Those are the two big issues.
Yes, those are the two big issues. And that part of the inadequate site plan submission doesn't allow us to establish what the existing conditions were when the permits were issued, or to measure from that point whether the ordinance has been complied with when carrying out. So that's not an issue for this board, but because of the requirements of the submission, one of the requirements is that you establish, yes, this is exactly how big my house is. So that when someone inspects it, they can say, okay, you didn't make it any wider, you didn't increase your footprint. And because none of that information has been submitted, there's no way for anyone to determine how to proceed from here.
Okay.
Any other questions? Attorney Lyons?
Great, thank you. I'm now going to do the share screen function. I believe I have, there we go. Can everyone see this?
Yes.
Okay, so I'm going to start a PowerPoint slide here. Apologize, we got lots of screens. Okay, can everyone see that? We'll take silence as a yes.
Mr. Lyon, I ask that you send this PowerPoint to Mr. Huber after the meeting concludes, please.
Yes, I'd be happy to. Thank you. And just to clarify, Roger and the board, all our pre-file written submissions are part of the record. I don't have to move for their admission.
No, they're all part of the record.
Okay. And then, yeah, at the conclusion of this PowerPoint, I move for its submission into the record at the suggestion of Chair Martin. Thank you. So we're dealing with the waterfront lot here, and I just wanted to reorient everyone. This is the snippet from the plan that was provided by Pliska and Day. The waterfront lot, cleverly named, it's on the water, abutting Pushaw Lake. And then the back lot, which we'll discuss in the second permit, is set back from the road. Regarding the retaining wall, so as I understand it, the Ms. Fitzgerald and the Watts are saying that the Spreckers went out and without a permit and built a wall or expanded a wall, or I'm not really quite sure what they're saying, but then they did this without a permit, and then they invited the code enforcement officer and the DEP to their property to then get a permit to do additional work on the wall. So I just find that that argument just a little confounding. The record has ample evidence that this wall, which was a previous foundation for the camp, has existed on this property for decades. As was provided in our materials, Exhibit N, you have a building plan showing the camp located in this general position on the water. You have an application, you have a second survey from 1990, Exhibit D, that we've provided, again, showing location of the old camp. And then, as was noted by Attorney Foster, you have an updated survey by Pliska and Day that, while, again, they weren't attesting to the exact location of the foundation, the surveyor was there, this was back last year in the fall, and said, yes, there's we call the foundation. As far as no other evidence being in the record, actually, when reviewing the files, if you look at page 67 on part 2 of the code enforcement officer's file, you see, and you see a picture, a photograph taken, and we believe it's in 2004. It's associated with materials relating to the 2004 building permit. The handwriting at the bottom appears to be similar handwriting to, we believe it was the previous owner, Brian Thompson. And so here's a photo right here of the wall on the property. So as far as the evidence of the wall's existence, it's ample, and there's plenty for you to draw from the board's own conclusions. Whether the code enforcement officer, and I look forward to hearing his recount of visiting the property, whether he determined that there was a stone wall, a foundation there that work could be done on. In addition to this, you'll find in the file that the previous landowner also, in an email that the Watts provided, and they asked, what about this old foundation stone wall? And he says, well, the only thing I can think of is the old pile of rocks across the front of the camp that was torn down. It did form a border and retain garden soil, and at that garden patio level. It was more or less built up level under the old camp. So we have evidence there, not only now pictures from the previous property owner, but also a statement saying the old wall existed. And again, you can see here's a picture from this perspective. The old wall is deteriorating and it's falling down. It's a very old wall, and but it's served its purpose for a long time. Joe and Mindy reached out to CEO Murphy back in May and asked, we want to do some work here on this wall, to repair it. And CEO Murphy then reached out to John Cullen. These are all shown in the emails and the exchanges that we provided to you, and are also shown in the CEO's file, documenting some of his conversations. And again, he's here tonight, and I'd be happy to welcome his perspective. But Joe and Mindy reached out to John Cullen, or to CEO Murphy, who incorporated John Cullen from DEP, and John Cullen came down in, after a series of emails exchanging what they wanted to do, and after CEO Murphy visiting the property, the DEP issued a permit to rebuild or retain, the semantic, I think it's a nuance here, but to fix the wall. And again, the board isn't here to deliberate how the wall has been fixed. Has it been fixed properly? That all has to be, resolved with the CEO and the DEP at a later date. You're just here to determine whether the permit was issued properly to fix this wall. So, significant evidence there as to whether it was issued properly is the DEP determined that this wall needed to be fixed because of its protection of the lake and what it provides for erosion control and prevention, and then issued a DEP permit by rule to do just that work. Now, and it's true, your ordinance allows for non-conforming conditions to be continued and repaired. The reason that, when Joe and Mindy asked the, CEO Murphy and John Cullen, to come to the property and to what should we do with this wall? CEO John Cullen said, don't take it down. You need to repair it. This acts as erosion control for the lake. It's better to have this wall that's retaining the soils that are currently on the property than to do anything else with it. And that's why he permitted this wall to be repaired. Taking it down would cause more damage than doing the repair work. Now, as far as evidence is of erosion and control plan, yes, technically there's no written erosion and control plan in the record. However, you have substantial evidence showing that CEO Murphy has inspected the work that had been started that's now been paused because the appeal is filed. He visited the site numerous times. You can see in this picture here, this is part of the record. There's silt fencing that's been installed by Joe and Mindy with direction from CEO Murphy. He actually visited on multiple occasions and spoke with them about, well, I think you need to move the silt fencing closer, and asked them to actually make improvements to the erosion and sedimentation control. So while you have a written plan, you have the CEO visiting the property and in discussing the erosion control plans and ultimately signing off on them on July 31st, which is in his file. As well, you have DEP and John Cullen inspecting the site on August 3rd, and reflected in an email from Joe and Mindy to John Cullen, where they provided pictures, including these pictures of the soil, the erosion control work that they had put down at his request after visiting, saying, "We'll cover this up while the appeal is pending, and then once the appeal's over with, you can come in and bring in your soil, and you can seed that soil." So they've been communicating frequent communication with the CEO and the DEP about how best to do this work on the wall. As far as the email from John yesterday, when John and I had a conversation, we discussed a number of things, but as far as what, if this is the DEP's position that, they haven't made a final determination whether the work has been done properly, that's fine. It was my understanding from talking to Joe and Mindy, was their understanding from their conversation with John on August 3rd, that they had done everything in compliance. In the end, one, that's not relevant to your review here, and two, they will have to be in final compliance because of the permit. Again, we're continuing to work with CEO Murphy and DEP to make sure that all the work is done properly. Again, you can see they've been employing a number of erosion control measures while working with the CEO and DEP.
We would object to the continued reference to what these folks have been doing with DEP and with the CEO. It's not really relevant to your consideration of what is in the record to establish whether or not they were entitled to these permits. Any conversation they may have had with Mr. Murphy about erosion control is not before you. You don't know what erosion control measures were taken or whether they're effective or anything about them, really. The evidence is not in the record before you.
Well, there's photographs, and there's actually is evidence in the record from the CEO saying in some of the additional files, his notes saying, I visited the property, discussed erosion and sedimentation control measures, and they're compliant. So, I think there's some nuance there. Also, the code enforcement officer is available tonight, and he, to provide additional evidence of what he's seen and what has been discussed. So the record's not closed on any of this yet. Moving on to the egress. So here's a picture of the property. Again, you see the old stone wall, and you see the house, and you see that there's no exit on the front of the house. And while there are exits in other parts of the house, safety, a family of 5 with 5 children, having egresses that allow for an exit if there, again, there's 4 stories. So there's a lot of house here. If there's an emergency, you want your children to have, relatively quick access to get out of the house. And as far as the, evidence going towards whether this is a lawful expansion, you do have an email on your record from the CEO where he's relaying that he's received an opinion from the DEP that these types of limited, again, we're not talking about a deck, that we're not talking about a patio, we're not talking about anything that, we're talking about a door, we're talking about a 5-foot wide landing and stairs. This is not some massive expansion. It has no impact on the environment. It's not going to increase erosion and sedimentation and all these, concerns that the appellants are asserting. What it's going to do is it allow to have an additional exit for the family to get in and out of their house. It's not going to be big enough to put the record also shows originally there was a patio located on this stone wall. That patio was part of their original application was we want to move the patio back, and then we want to, with the same configuration but farther from the water, where we would like to, be able to put out a barbecue or chairs or such as that. The email that's in the record from John Cullen says, no, I'm concerned about that. I'd like you to try to get farther away from the water if you can. And Joe and Mindy said, that's fine. We'll get rid of the patio. Again, this is not, this is an exit. This is for people to get out of the house. This is nothing beyond, the concern for safety of your family. So with that, I just want to get to the last point, and Attorney Huber brought it up at the beginning, in that, that all these assertions of improper removal of vegetation, of unpermitted parking along the side of the house, none of that is relevant to the board. None of that is relevant to your review here. All they've provided for evidence is a grainy picture that has no date, that we don't know who took the picture of. We don't know how old it is. We don't know if it was when it was taken. Did the Spreckers did Joe and Mindy even own the property at that point? And again, it's not relevant. And I just want to remind the board, and here's the provision of the ordinance that Roger cited, that anything that goes to alleged violations or anything along that is not properly before the board here. And then if you give me just 1 second. So that's all I have to discuss on this permit. Again, the burden's on the appellants. There is substantial evidence of compliance and that the permit was properly granted. Now, if I'm going to ask if Joe or Mindy would like to say anything, and I will. I'm going to text them right now. If they were in the room with me, I would just turn and ask them. But just 1 second, please, if you'll entertain me. Yes, that Joe and Mindy would like to provide a few comments, please. And I will take off share screen.
Joe and Mindy,
You guys are muted.
you're on mute, so I'm going to speak real quick. And I'm going to ask the same of Mr. Watts. I should have. I asked the parties that were going to testify at the outset to swear on an oath that they were going to tell the truth, the whole truth. Yes, from both of you. You're muted.
We good now? Can you hear us?
You're all good to go.
Okay.
Hi. Thank you all for being here. This is an important and challenging issue, so I appreciate your consideration in it. I wanted to note that we have not brought in any fill to our shorefront lot. I was taking some notes as things were going through, and you can see from the evidence in CEO Murphy's file that the lot was level prior to us moving in here, as well as Mr. Thompson's email that occurred, that was sent to the Watts, saying that the old foundation brought it up to the garden patio level. That's not new work that we've done. That we've worked very, very closely with CEO Murphy. I admit there's no erosion control plan on file. We installed silt fencing. CEO Murphy came out on 3 different occasions to inspect our erosion control plans. We dug a trench. We have hay bales installed on the other side of the silt fence. And then following John Cullen with DEP, his recommendations, we would have absolutely seeded, had sod down, everything would have been contained. But then the appeal occurred. So it made sense to pause that work. So based on Mr. Cullen's recommendation, we spread the hay mulch to make sure we love living here. This is a challenge for all of us, and we had no idea that this would happen. We have been working hard. We bought a foreclosed property, and we've been very, very diligent in trying to improve our home. Last year we spent working on the inside, and this year was to work on the outside. So in May, we started working on the back lots so that we could generate a parking area. So any work that was done, we borrowed someone's tractor, my mother's tractor, to be able to do work. We don't own one. And so all of that was done prior to anything that was occurring on the shorefront lot other than cleanup. There were a lot of random rocks that were around, and we didn't change that landscape at all. And we knew in one of the emails I messaged, or I think Joe, I messaged Bill Murphy, and I had asked him about the status because we were wanting to do the work because our summers in Maine are so short. We wanted to make sure to be able to do what it is that we were hoping to do, because this is...
Excuse me. I would renew the objections that Mr. Lyons made during Dana Watt's testimony. Please stick to the issues that are relevant to whether or not the shorefront parcel has been in accordance with the evidence submitted in accordance with the shorefront parcel. The details, while appreciated, I understand that I completely appreciate that this is your home and that you're trying to improve it. They're not relevant to whether or not the ordinance has been complied with in this instance.
Understood.
Well, I just want to counter that. Mr. Watts alleged that they were moving stone and building up the foundation before any permits were made. So her points to moving rocks and leaving things alone are very relevant to those assertions.
They just said that they were moving stones.
These were literally not big stones, not anything to do with the stone wall, none of that. These were not substantial things. These were so that we could walk barefoot.
There was concrete and debris. It was a foreclosed home. There was debris. The place was, we've greatly improved it. We're so sorry that this has come to it with our neighbors and that it's come to fruition here. It just,
John Cullen said when I sent him a picture, I don't understand what's going on here. It looks like a bomb went off, because that's ultimately what it is that we took on when we bought a foreclosed property. There was the only movement of any kind of earth occurred in one day when those the boulders were brought down, and that occurred in one day. So there has not been any shifting, moving of any vegetation. As for Pligsett and Day, we asked them to focus on our back lots because of the conflict that we were having with our neighbor in our attempt to try to navigate that. We asked them, we were really clear with them that that was our purpose in getting this survey. We went back to him, he remembered, recollected seeing that wall there. There is an email with John Cullen. I was with CEO Murphy. We measured the distance from the water to the wall. And there was also an email, there was a request from Mr. Cullen with DEP with regard to the distance from the water of the wall. And that was also there. There was no mortared stone with regard to the house foundation. This was an old camp. There was concrete on one side relative to the foundation. And we did pick that up off the ground, but in terms of the structure of the wall, there was no mortar associated with it. And as far as the driveway going down the side, there was some gravel, small stones down the side of our driveway. We haven't been driving things up and down there. We didn't even bring our borrowed tractor down to the shorefront because we understood that shorefront work is important. It's important to protect our natural resources. So we didn't even touch the shorefront lot.
prior to getting the permit.
Prior to getting the permit. And that was all that I wanted to say.
Chair Martin, am I entitled to cross-examination?
Well,
Roger, please advise.
I think you are, as soon as Patrick says he's done with his witnesses.
Yeah, no, I'm all set.
I just have a few clarifying questions about some of the statements that you made. What boulders were brought in?
They were the large stones, boulders from the back lot used. We were suggested by Mr. Cullen and Mr. Murphy to, instead of removing the wall, to create the new face of the wall in front of the existing one, because that would interrupt, if we were to actually remove it, that would cause more disruption.
What is your opinion of the fact that Mr. Cullen wrote in his email to us that the wall is in compliance if it is no closer to the water, but based on what I've heard you say, placing a boulder between the existing wall and the water would in fact make it closer to the water?
His specific direction was to surround the existing wall. So you're right, physically impossible to surround something without making it larger. That's a physics problem. So both DEP and CEO, yeah.
My understanding is that our compliance with regard to DEP isn't at issue here.
I was just asking about the expansion of the wall because of the statements that you made, and the fact that I was wondering where in your permit for the town of Orono you delineated what was needed for repairs to the wall. Do you have any information on that?
His specific, John Collins' specific direction in the email to us was make sure the wall is no higher and no longer than it existing was. And we have ensured that it is no higher and no longer than it was existed. And we followed their direction to completely surround it, to completely shore up the existing wall. It's still there. The wall is still there.
That's not what I asked. I was wondering what repairs you applied for and what repairs you had explained to Mr. Murphy were needed when you applied to repair your retaining wall.
We showed him the deteriorating wall, and discussed our desire and need to bring in something to shore it up. He agreed, as did Mr. Cullen, that we could use existing material that we have. John Cullen asked me specifically what we'd be using. I said that we could use stones from our property, from our back lot, in order to shore up the wall.
Understood. Why was so much soil disturbed that you needed to spread the hay?
That ultimately there was a machine that came down in.
An excavator. It
Yeah,
requires
it's
an
a-
excavator to move boulders, so that disturbs soil. And we made sure that all the soil erosion techniques that were required with the silt fencing and the hay was in place prior to.
We were diligent and made sure we had satisfied CEO Murphy's concerns about the erosion and as far as the erosion control issues. And it was when DEP came to our property for a site visit, he suggested, because of this appeal, that we do that as an additional step. So we had already satisfied CEO Murphy's request. And then because this has been delayed, it made sense to take that additional step.
And to be clear, again, we're not talking about compliance. It's not up to the Board of Appeals to make a ruling on compliance.
Understood. I'm just asking where in the submission that you made for your application, there was discussion of bringing in boulders or a significant amount of soil disturbance or how the hay would be laid. And what I understand from your response is that there wasn't anything in your submission about that. That was all conversations that you had with Mr. Murphy and Mr. Cullen outside of any written submission.
Correct. We do not have an erosion control plan on site. Bill
Okay.
Murphy has visited our property at least 6 different times, routinely, sometimes calling us ahead of time and sometimes stopping by.
He was here 2 days ago.
Mhm.
Okay, and I just have one more question for you. If I could refer you to page 19 of 44 of the exhibit of the submission that you made or that your attorney made on your behalf. There's a site plan drawing in there, and I think that, I don't know which one of you, but one of you did the illustrating.
I drew it, correct.
Okay, could you tell me why on this you illustrated the existing patio and former foundation as a square, and then separate from the former foundation, you illustrated the retaining wall?
The patio, that was stricken, and we talked about this
Yeah.
already. We struck with email communication with DEP when he said, the patio, I don't think you should keep the patio or move that back. We said, fine, no patio. That's a moot issue. That's not part of our permit.
It was a flagstone patio that Brian Thompson confirmed in the email that he sent to the Watts. And because people had concerns about it, we said it's okay. And we just simply removed it.
I understand that you removed the patio from consideration, but you had written on this plan former foundation. And so I was wondering what your motivation was when you wrote on this plan, this is the former foundation, this is the square, and
Yes.
then you showed where the retaining wall is. And those two things on your site plan that you submitted for this permit, those are two separate structures shown on that plan.
The former foundation is the existing, what has been the retaining wall for soil for 100 years. That it's a flat area. We're simply trying to fix it in compliance with the town and the state regulations. We've painstakingly taken many steps to do that, and this is just continued harassment.
I understand what you're saying and that you're saying, but I'm referring you to this map, and as you can see, I'm kind of trying to show you it. They're shown as two separate structures. And so you understand why it's confusing when you're looking at that, to understand what was the existing former foundation and what was the existing retaining wall. And I was just offering you an opportunity to
The former
explain why you
foundation is,
showed it that way.
yes, the former foundation is a square. It's drawn as a square. That represents and it exists, just as DEP Colin has told us that retains soil, to not remove that. So we haven't removed that. That foundation is still there. It's underneath the rocks that we went around. We followed every possible, sorry.
Ultimately,
the
I
question you can
believe-
ask here. Oh, go ahead, Mindy.
Well, I believe what Joe is trying to express is that was trying to demonstrate that is the old foundation. He That is all, that was part of it. And so representing it in that way. This is our first time doing it. And we have been asking lots of questions and tried to be very communicative and responsive, and make sure that we're doing the right thing at every step. And in this particular circumstance, he maybe shouldn't have completed the square and just indicated old foundation serves as retaining wall. And that probably would have been a greater clarifying point.
And I just have one final question. Where do you intend to add the 15 to 20 yards of the 15 to 20 yards of fill to your property?
In the center, just behind the retaining wall.
So
Right now, it's a caved out area. Right now, the water just would wash that out, would wash out that retaining wall if we don't put in a level area the way it was.
Is this the retaining wall?
That is the old retaining
The old one.
wall.
The old retaining wall?
It's also the old foundation.
Is there a new retaining wall?
There is the new retaining wall, or it's the replacement of what was there.
Mr. Lyons just showed pictures of the newly fixed and repaired retaining wall. It's done.
Mhm.
It's just waiting for dirt and grass. We're on hold
I'm
because of this.
confused because you just said there's an old retaining wall and a new retaining wall.
I can
I'll just
clarify.
I'm all
I think that's semantics.
That's
No.
I can clarify it. So there's the old retaining wall that has existed there for decades. And then with your permits that were issued to you by the CEO and the DEP, you brought in additional boulders to shore up that retaining wall, correct?
Yes,
And that was at
that's
the
right.
direction of DEP.
Mhm.
And that's what's there today. And then you've stopped doing the work on it because of the appeal.
Correct.
Yep.
So you didn't build a new wall. You've just shored up the existing
Right.
retaining
Existing
wall.
wall. And we haven't brought any more dirt, haven't brought in any dirt on the short front lot.
Okay. I think that clarifies.
Again, that's a compliance issue anyhow, but whatever.
That concludes my series of questions. I'm all set. Thank you.
Chair Martin, take over.
No,
Attorney Lyons, do you have anything further you'd like to add, or should we move on to,
I'll just, one last question for Joe and Mindy. Did you build any additional wall before you were granted a permit?
No,
No.
no, absolutely not.
Okay, thank you.
It-
That's it. Thank you.
all right, then, Mr. Mylan?
Roger, could I just clarify the role of the CEO in this process?
Sure.
What is Mr. Mylan offering for testimony?
I don't know.
Well, what is the purpose of the testimony? Like, is it meant to talk about this fact specific situation, or is it just a general, this is how we typically, I'm just curious because I think that it could be confusing to the issues if there's a lot of discussion about what the CEO did or didn't do, or conversations the CEO had, because as you stated at the outset, what the CEO did or said isn't really relevant to the discussion that we're having tonight about whether there's adequate evidence in the record.
Right, and I would stand by that.
Okay.
I think what the code officer in his office have to stand is to provide at least some guidance if the board feels it needs any for those people that administer their code day to day.
Understood. Okay, thank you.
Hi, folks. Ms. Foster, I would say that if I start going down a road that you don't think I should be, please don't hesitate to say so. That's not my intentions.
No, I know. I wasn't trying to accuse you of anything. I just wanted to be clear on what the process was. So that was it.
I understand. Thank you, ma'am.
And I'm sure Attorney Foster doesn't want to be rude, but her point is well taken. I mean, this is not a review of what the code officer did, but you and the code officer have some specialized knowledge with respect to the code that may be of use to the board members if they choose to ask.
Thank you. As I said before, that the practice of issuing permits is not done in a court of law. It's done done on the side of the road. It's done in someone's backyard. It's done on the waterfront. And so there is not the common practice of working through a permit process is a intuitive conversation between an applicant and and the code enforcement officer. And what I wanted to share with the board that I don't feel is intuitive is how if a permit application were coming to the code enforcement officer today, unrelated to this, how they look at what needs to be provided and how they determine whether something has been satisfied or not as far as information. So when I say that it's not done in a court of law, they don't check off a list that says this has been provided, this has been provided, this has been provided. What they're here to do, if they need to testify, is I did all of these things when I went through the process because that's what the process requires. So, and an example is you've had some conversation about erosion and sedimentation control plan. The ordinance requires that plan is submitted. The ordinance was created, the shoreline zoning ordinance was adopted here in Orono in 2000, the current version of it, and that requirement was in there. In 2003 and again in 2014, Maine DEP created and updated the Maine Erosion and Sedimentation Control Practice Field Guide. That is a document that tells contractors how to abide by all of the rules and regulations pertaining to erosion control. We look on all of those cases, we tell the applicant that they are required to abide by that guide. That's considered the plan that is submitted. And in this case, and in any case, the code enforcement officer has a conversation with the applicant on how best to do that because every property is different. And you have to go out and walk the property with them and give them guidance. And it's oftentimes in combination with we work a lot with John Cullen with Maine DEP. So oftentimes, because there's a DEP permit involved, as well as a town permit involved, they work together and oftentimes are meeting at the same time to have conversations with the applicants on how best to achieve those. So we would look at an application as meeting the requirement of submitting that plan by utilizing the best management practice guide that's provided by MDEP. And if they have questions with it, as CEO Murphy does on a daily basis, he works with the applicants to do what needs to be done in order to best qualify it. The second thing that I wanted to share is regarding there was a conversation about the landing. And in our notes that we had submitted, you will see, you may notice that the CEO had some concerns about the first plan for the landing for the stairs, and he made some suggestions to the applicant, and they updated their plan with a new location, taking into the consideration what he proposed as far as moving that landing. The landing itself.
Sorry, I really don't want to get into discussion of what the CEO thought about the application. I don't think that that's relevant to this board's evaluation of the evidence that's before. I don't mean to be rude and interrupt you. I think that if there are questions for you, that's fine. But just because of the standard of review here, any conversation about what the CEO did or didn't do or how he evaluated it is really immaterial to whether or not there's sufficient evidence in the record to grant these permits based in the Board of Appeals opinion.
And I will defer to Roger. I guess my position on it, Ms. Foster, is that this board is reviewing an application without the knowledge of how those things are evaluated. And all I'm trying to provide is the knowledge that the code enforcement, not this case specific, but the case that he would do on any case, as how he evaluates whether a standard has been met. If that's not helpful to the board, then I agree. I'll defer. I'll leave that to Roger and the chair.
And Roger, let me just clarify. I understand what Mr. Milan is trying to do and how he's trying to be helpful in this instance. I would argue that this board's requirement is that they evaluate whether the ordinance has been complied with. It's not really relevant how the code enforcement officer would have evaluated these matters. It's about whether or not this board has determined that the ordinance has been complied with based on the record evidence that's before them. So any conversations that the code enforcement officer had outside of the scope of that are not relevant to their consideration. And I would really try to urge this board to stick to the standard of review that is passed down to them so that we may be sure that we're complying with the ordinance.
The fact that a conversation the code enforcement officer has with an applicant regarding requirements for these ordinance, one, goes directly towards the requirements of the ordinance, and two, and by it being presented here tonight, it is thus evidence. So I think, the board.
The evidence on which this board is meant to rely is the written submissions in the record. And the code enforcement officer had every opportunity to write a report of his meetings with Mr. Sprecher or other meetings that he may have had and to include those in the record. And frankly, he has included a detailed timeline of how he evaluated this project, and that's in the record. So
it's your position that he can't provide any more evidence then?
The evidence has been submitted for review to this board. It's not my position that he can't provide any more evidence, but when this board is evaluating.
It's testimony that this is evidence for the board to consider.
In
essence, you're trying to
I don't want to argue with you, Patrick. I just was giving my position and that's it.
I'm giving mine, that the CEO should be able to provide testimony and evidence here tonight in addition to what's been submitted on the paper. You did the same.
For the board's benefit, I think the board understands that its review authority tonight has nothing to do with what the code officer did. The question before the board is, should those permits have issued based on the record and the evidence that's before you tonight that you've received in connection with this evening? I appreciate Attorney Foster's point, and to the extent that Mr. Milan's testimony discusses what the code officer did, it is probably not relevant to these proceedings. I don't want to give up on Mr. Milan's expertise and the code officer's expertise. I guess I would ask the board if there are questions that you all have with respect to the issues that you've heard from the two attorneys in terms of how the code works on those issues. I would encourage you to ask those of Mr. Milan, but I think beyond that, we certainly appreciate Mr. Milan's attendance and willingness to offer that guidance, but I think that's the direction we ought to head off in. So I would ask the board, do you have questions of Mr. Milan with respect to application of the code, what the code requires, in connection with the issues that you've heard this evening.
Yes, I'm wondering if Mr. Mylan thought that the site plans that were submitted were acceptable.
I would object to Mr. Mylan's opinion on whether they're sufficient is not relevant. It's your job to determine if you think that the site plan that's submitted was sufficient.
And Attorney Foster is absolutely correct. That's your determination.
The thing is, it seems as though a lot of decisions were made on the run in communication and not necessarily on paper. And I guess I'm struggling with, is that okay in this kind of an issue? Just because it's not in a written record, it was communication between the Spreckers and the code enforcement officer and DEP. And they did things because they were told to.
I would suggest that those are questions that you ought to pose to your board members during deliberations. We probably ought to ask the parties if they have any other follow-up. I think we need to make certain that everybody has a chance to cross-examine the witnesses that have been called. And perhaps each of the attorneys would like to take a minute or two to sort of summarize their positions before the public hearing is closed and the board goes into deliberations.
But I do have a question for Mr. Millen about the plans that you talked about. You say when a codes officer reviews the plans, there's no real plan set out, but they look at there's I don't know what you called it. So I would ask you to kind of state that again from 2003 and 2015. Is that what you said? Those specific plans? And they refer to that? I was trying to keep up with you on that. So
I apologize if I was going too fast. What I was saying was that there were some, when we look at whether a erosion and sedimentation plan has been submitted, we consider it submitted when we tell them, the applicant, that they need to utilize the main erosion and sedimentation control practice field guide. That is the sedimentation plan. And we consider that requirement fulfilled. The dates, what I was saying was that when this ordinance was created was in 2000, and that's what the language says, that a plan must be submitted. In 2003, the main DEP created this best management practice booklet, and then updated it again in 2014. We refer to that, all applicants to that, and in the permits, we have what I call boilerplate language on the permit that says all erosion plans must be followed. And so we do that for all of our permits. And so our conversation with on any applicant is to, if you're not sure what you're supposed to do, that's the guide that is the prevailing guide. And if you have questions, let us know. And that happens all the time, that they have questions, and we verbally have that conversation with them as to what the plan should be for that particular property.
So could you clarify the point that, okay, in this case, we're looking at a homeowner, more than an acre lot, I don't think, a small lot. So you would use this plan and booklet in this situation. But if somebody was building, 100 apartment unit construction off of Park Street, yes, they'd probably have to get in an engineering consulting service that would fully look at soils and do, test pits, et cetera, et cetera, et cetera. So how it's handled, does that depend on the scale of the project? Turn it over to you, Mr. Milan.
Oh, great question. I will say that though a a formalized plan typically is involved with a subdivision or a bigger project, all of those plans are still based on that same document, regardless of the size. Where it's located so even on our subdivision reviews, we still use that particular plan to say if they're deviating from it, why are they deviating? That's the standard plan that we use, regardless of the size.
I guess where I was going was more it seems that this was sort of an informal discussion and not necessarily production of soils engineering documents. I'm saying, would you look for soils engineering documents on larger scale projects versus a homeowner? You would do it with different types of documentation, a different process. Is that a true statement?
That's fair.
That's all I have.
Anything else from either party?
I would just like to make a few closing comments if I could. Am I first?
You go first.
Okay, so as to the erosion and sedimentation control plan, your ordinance currently requires that someone doing work in the shoreland zone comply with the land use standards in the shoreland zone. So whether or not the typical practice of the code enforcement officer is to defer to the certain state standards for erosion and sedimentation control, it's not clear from the record that's before us today whether they had that conversation with the Spreckers or whether that was employed by them. We have no evidence to suggest that they were discussing this document. There's no reporting of it. There's nothing in the record to help us understand how erosion and sedimentation control measures have been employed on this property. There's some photographs of some hay and some photographs of some silt fencing, which we understand on August 3rd, when John Cullen visited the property, he asked them to put in place. August 3rd was long after these permits were applied for, and some work was done in between there. So this isn't really relevant to our discussion tonight because that's about the DEP permit, which was approved and has not been appealed. So what the DEP did or didn't do in the meantime isn't really relevant to this conversation. It's whether the Spreckers have complied with the town of Orono land use ordinance when they were applying for receiving these permits, and whether there's adequate evidence in the record to establish that they are entitled to them. And we would argue that they have not complied with the submission requirements in the ordinance. These are simple things like site plan, which doesn't clearly show, and as you heard from their testimony, there's clear confusion about exactly where the retaining wall was, where the old foundation was, or what's going on. They said themselves that they probably should have been clearer in the site plan. That is not an establishment of existing conditions as the submission requirements state. Additionally, there's been no conversation of whether or not there was an analysis of whether the non-conforming structure was evaluated or understood to be complied with. Yes, there was a revision to the plan after a conversation with CEO Murphy. We do not know, and there's no evidence in the record about what that conversation was, what was discussed, or how it was determined they were entitled to expand the structure in this manner. Further, and finally, as you heard, there's been large boulders added to the front of the property in order to shore up the retaining wall. Whether or not this is common repair is something that I think that this board will need to decide. It's certainly an expansion of that retaining wall to make it closer to the water body. So when a non-conforming structure is expanded, whether that was by instruction from the CEO or by the DEP, a permit is required for that work. That is beyond repair. That is an expansion. It is closer to the water body, even if that repair work is meant to just shore up the retaining wall. So we would argue that on all three of these points, there's no record evidence before you submitted as part of this application process that would help you or I or the neighbors or the abutters or anyone in town who wasn't privy to these personal conversations understand what is happening on this property or whether the land use ordinance has been complied with in this instance. Thank you.
I just want to remind the board that the burden of proof is on the appellants to prove to you that the ordinance and requirements were not complied with. And I also, a lot of what's been argued here tonight, either one isn't relevant, it goes more towards alleged enforcement matters, And then two is really form over substance. There, we've had, testimony from, Joe and Mindy, information from the town, from Mr. Malin that, what actually takes place on the property, how these things get done. The fact that a best management practice document was shared. As they said, they share it with every applicant, and that's what they go by when they're doing this work. And again, the CEO then visited, and you see pictures of you've seen pictures, you have evidence before you of the work that's been done. So again, I think there's substantial evidence in the record. Joe and Minnie have done everything they can to be in compliance through numerous conversations with code enforcement officer and the DEP. And at the end of the day, the appellants hadn't met their burden to prove to you otherwise. So thank you.
Mr. Chair, I think you can close the public hearing if, and proceed to deliberations.
Without objection, I will close the public hearing. Is there any objection from the board? Being none, the public hearing is closed.
And just so this board's clear in its deliberations, if you get to a point where you would like to ask any of the witnesses for clarifications as to what they said, you should feel free to do so. They now speak to you at your permission, without right, but that is certainly your prerogative as you move through deliberations.
So I believe we need to start with someone making a motion.
Correct.
Mhm.
And it's a difficult motion to make, whether it's in the affirmative or in the negative, because you're not. I don't think you're really talking about the entire permit. You're just talking about three of the activities that were permitted under the permit. So maybe it's. I'll leave it up to the chair. Maybe it's useful to have three separate motions and discuss each of the issues individually. One being the addition of the 15 to 20 cubic yards of fill to the earthwork to repair the retaining well, and then 3 to slide the patio and the landing.
If we determine that some of the permit should be denied, but the other parts of the permit are allowable, does that approve the appeal or does that deny the appeal?
Both. It approves it in part. And denies it in part.
Thanks. Big help.
Yeah, very big help. So I can pay the big bucks. Say smart stuff. Would you, Mr. Chair, do you have a preference as to how to proceed with those either three, or with trying to frame a motion that addresses all of them?
Splitting the three will help with discussion, though it's, if you could articulate the three and then somebody can move and then we can, I'm just trying to remember how old Robert's Rules of Order on this. You can't entertain three motions at once, correct, Mary?
I don't know that you need to entertain three at once. I've got a form motion that I'm pleased to offer for someone to advance, if that helps move things along. I phrase it, it can be phrased either way, that the appellants either have satisfied their burden or have not. I happen to have written it in the positive, but only because I think it reads easier that way, but I don't want to persuade anybody in that direction. It's not intended to do that. It's not intended to give any indication of how I view things at all. It's just, I think it's easier to write a motion in that way.
Because we've done them in the negative before and it gets too mentally confusing.
It's ugly. So how about this? How about I just throw this out there, entertain a motion that the appellants have satisfied their burden of proof to demonstrate that the code enforcement officer erred in issuing building permit 2098 to allow for the addition of 15 to 20 yards of fill to the shorefront lot. Obviously, you're all blown away by that. Really, seriously, stand down. Yeah.
Mr. Chairman, Mr. Chairman,
Yes, sir.
might I suggest rather than splitting the motion, that we make a common motion that either the appellants have prevailed or not prevailed. And then that motion, if we find in deliberations, it would be helpful to split the questions. That motion can then be modified, amended to do so. But I suspect that the discussion on all three of these issues will have a great deal of commonality associated with formality of the documentation versus standard normal practice. So
Shall I try again?
if that works, I would be happy to just put forward, and I'd plagiarize Roger's motion shamelessly, to put forward in an affirmative that the appellants have demonstrated if
They've met their burden of proof.
words again.
Would you like me to read it just in case? Yeah, I'll read it. It says appellants.
Yeah, read it and then we'll go from there to get the words right.
Appellants have satisfied their burden of proof to demonstrate that the code enforcement officer erred in issuing building permit number 20-098 to Joe Sprecher, or I'll just say to issuing building permit number 20-098.
So moved, Mr. Chairman.
Second.
Okay, the motion having been moved and seconded, we will now enter into discussion of the motion.
Chairman, having made the motion, I believe the issue before us is the formality with which the application for the permit was executed. The question of the erosion control plan, the question of the analysis and justification for the landing extension, and the details of the repair of the retaining wall being an issue. I think we should discuss whether the informal approach to having granted the permit was sufficient practice, even though it may not have met the letter of the all of the ordinances. Is it sufficient by which to satisfy issuance of the permits, or do we need to send this back and have the permits reapplied for, if that be the applicant's pleasure, with more formal documentation and have that permit then reconsidered and reissued.
Right. Because I think we have to consider that if the appellants take this to the Supreme Court and there is nothing in the record, like site plans and soil testing and that sort of thing, the court will certainly say, well, I mean, if they want to hold the hard line, it's true, that's not there. So I think we have to take that into consideration.
I agree with you. Main reason I feel the appellants have met the burden of proof is incomplete record applying for the permit.
Yeah.
Perfectly said.
I agree.
You know, we don't have the documentation that, you know, should be there in order to approve the permit. And it doesn't matter whether it was post facto, whatever it is, if it's, you know, talking between two people, if it's not actually written down somewhere and in evidence, then I don't feel that the appellant has, I mean, I feel the appellant has proved their point. It's an incomplete plan, should not have been approved.
Right.
And what do you think was missing? And I'm the scrivener. I get to write the decision. So I just want to make sure that I'm clear as to what all of your viewpoints are. When you say incomplete, do you mean the lack of a soil and erosion control plan, a lack of a complete survey or site plan?
Mhm.
Yes.
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 May I suggest that first, yes, the missing erosion and sedimentation control plan as it applies to adding 15 to 20 cubic yards of fill or repairing the retaining wall. Documentation of detail of existing condition and work to be done that comprised repairing the retaining wall, and analysis of the existing structure, the existing non-conforming structure relative to a request to extend a landing and a set of steps to grade.
Okay, regarding that final point on the steps, I think, and it wasn't really discussed, but it is in some of the material that we were sent. There are records of many, many building permits dating back to when the current building was first built. I mean, there's documentation of various work and permits that went through the town to make that building. So it wasn't talked about much, but there's quite a bit of information about the structure in that material that we were sent.
But Mr. Chairman, the fact that we were sent a lot of material and that record, nevertheless, that record was not put in as support for the application of the permit. And so I think we're simply not absence of information, but the formality with which it was presented to the code officer for issuance of the permit may be at issue here.
Mm-hmm.
But the materials I'm talking about are part of the town records. I mean, this may be the point where we defer to Roger or to Mr. Milan, where, you know, this town has got lots of records on everything built on all of our various properties in town, and materials that we were sent via that file share, or I've printed off, you know, documents going back to the 80s for construction on this site. Roger or Mr. Milan? You know, how do we look at the records of the town? How do we look at what is the known records that are retained in the town office building here?
And those records are part of those records that were part of the file share are part of the record on those on appeal. Those are before you. Are you suggesting that there's information in that file dump that would help you decide the issue on the patio door and the landing?
I'm saying there's quite a bit of history of the construction of that building that not a lot of, I don't think we've, looked at in depth, but that information was presented to us. It wasn't really argued much by the attorneys. There was just broad claims that it wasn't provided. But, some of that, I believe some of it was provided to us. Has there been deep analysis of it?
Mr. Chairman, I would suggest that it's not the function of this board or this hearing to be aggregating information on the history of the additions and work that's been done on that particular building. I would suggest that granted that information is all in the record, I would suggest that it was for the applicant and the code officer to assemble that information and analyze it and put it forward.
I think that the point that Attorney Foster made was that the addition of the sliding door, the landing, and the stairs is an expansion of a non-conforming use. Attorney Lyons didn't, I don't think his defense was that it's not a expansion. I think his defense was this type of expansion is permissible under the law, or at least the code officer was led to believe or told or had the opinion that this type of expansion was allowable under the law. I understand the point that going back through the history of the property might be able to tell us whether we're at or beyond 30%, but I don't think anybody's arguing that the sort of the 30% rule, the allowable expansion, the amount that you're allowed to expand a non-conforming structure over the lifetime of that structure. I think the argument is more in the nature of, the law allows for this type of structure regardless of its size. So I'm not sure that, certainly nobody pointed to a law court or a case that said these types of expansions are permitted. So I'm not entirely certain that going back through the history of the property would offer anything, but that's the board's prerogative.
I'd like to say that I am going to vote for the motion, and I feel really bad for the Spreckers because I think they have complied with everything they were told they had to do. And I mean, that just must be horrifying to have bought the property and want to make it to a wonderful home. But as far as the documentation, that I didn't see anything documenting that the code enforcement had made all of these visits, that the DEP had been there. They had discussed the soil and the erosion and been advised to put the hay down or put the extra stones to protect that wall. And without seeing that kind of thing, I just don't see how we can say that the code enforcement had enough information for the permit. So I feel conflicted about it because I feel really bad for the homeowners. But in the case where I think code enforcement knew that there was a neighborhood dispute over this property already, then that means to me that you need really good documentation lest it go to a court.
Yeah. The other thing, members, that this was all happening as COVID-19 was hitting. There was nobody having face-to-face meetings. You had to call ahead. You couldn't just drop in on the code enforcement officer. It was,
right.
These were hard times in which to get a permit and then to visit and make sure the permit was you were doing what you're supposed to. So I just throw that out. I know we can't say COVID-19. We can't say COVID-19 is an excuse for everything, but anyway.
I'm hearing a consensus um, from all of you that it's more about a lack of information
Yes.
than information that sends you off with the permits ought not have been issued. You're saying that you don't have sufficient information. You don't have a soil and erosion control plan. Again, you don't have an adequate site plan. Remember that the scope of your review is whether you would issue the building permit based on the evidence that's presented to you, not whether the code officer had sufficient information. I just want to make sure we're all clear on that.
So I thought the issue was there was an error in granting the permit. So aren't we arguing whether or not there was adequate information for the code enforcement officer?
The code enforcement officer issued a permit. He did so based on the information provided. The question now is would you issue the opinion or issue the building permit based on the information and the evidence that's been presented to you prior to this hearing and as part of this hearing? Because if you say no, then your view is that the code officer made a mistake. I mean, that's why it's phrased that way. So if you would make a different determination based on the evidence that's presented from you, then you would say that the code officer made a mistake. The code officer erred. That's why it's structured that way.
I guess I would say there was not adequate information. I heard Bill's boss say something about a handbook. They use this handbook. Well, we don't have the handbook.
No.
So we don't have the information to know whether or not there was adequate attention to the requirements in that handbook for this project to go forward.
And for me, that's the one piece that I stand on is just that one argument is that we don't have that handbook. Exactly what you're saying, because we don't know how to point back to that erosion plan. So.
Right, but the information in that book that the CEO made his decision on should be part of the evidence we have in front of us.
Right,
It isn't.
right.
We do not have complete forms for the issuance of the permit. So it's an incomplete permit application from my point of view.
Mhm.
Mine too.
Yes.
Chairman? Mr. Chairman?
Yes, sir.
The point made by the appellants is strict construction of the requirements in the town ordinance and calling for a written erosion control plan, some evidence submitted in writing in support of each of these requested items of work. And I have, unfortunately, hearing this de novo this evening, this application for a permit to do this work, constructing strictly on what the code requires in terms of written this and written that, we don't have it, which is unfortunate because, well, I won't conjecture on what would happen had we had it.
So is there any additional discussion at this point from members of the board?
I have a procedural question on if this motion carries and we find on behalf of the appellants that they prevailed. I presume there is no reason that the permit application can't be resubmitted to the code enforcement officer. In other words, this decision is without prejudice in that regard. I believe that's the case. They could resubmit the request for a permit.
I wouldn't base your decision on whether or not the permit application can be resubmitted. And I guess I have my viewpoint, but I don't think it matters. That's not what's before you.
Yeah, agreed.
But what I'm hearing again, I'll just repeat it and make sure that everybody shakes their head and that I feel like I'm articulating, and I will do better in writing. But that it's really a lack of information. It's not a substantive. It's not a substantive error in terms of this particular work does not meet the ordinance. It's more of a submission error. And you don't have that sufficient information before you in order to say I would issue the permit.
Right.
Okay.
Yep. So
what would you like to do, Mr. Chair?
Is there any additional discussion? No. We don't do the little call a previous question stuff. We just take a vote, correct?
We just take a vote, but again, I've got to go through the we've got to go through the roll call. So again, just as a reminder, the motion is that the appellants have satisfied their burden of proof to demonstrate that the code enforcement officer erred in issuing building permit number 20-098. And I will articulate, that's the motion. And the rationale for that is the lack of a erosion sedimentation control plan, a lack of a complete site plan, a lack of evidence as to the existing condition and the work to be done on the retaining wall. And Member Smith, you were so articulate, and I wish I had written it down.
The extension of the non-conforming structure insofar as building the landing and the stair.
Shall I call for a vote? Shane Martin.
I vote no.
Gary Noyes.
Now, a no vote means they did not make a mistake. A yes vote means they did.
That is, yeah, a no vote means the motion is not going to carry, correct? Shouldn't carry, right. Paul Moore.
Yes.
Mr. Smith.
Yes.
Ms. Cathcart.
Yes.
Ms. Jane.
Yes.
The vote being 4-2, the motion carries. Chair, do you want to exercise your authority to give everybody a break?
Yes, 5-minute recess.
I expect, okay, and I expect the second half will go much quicker. One, it's just one issue, and I think much of the information has probably already been.
I'm showing 2044 on my little Garmin watch, so I would say reconvene at 2050.
Thank you.
Watch up top. So it says 2:42. So you're saying 2:47?
How come everybody looks so nice and I look so tan or purple?
You should have warned me that you need to eat dinner before you sit down to these meetings.
Normally, they haven't gone this long before.
Got them till 11 o'clock at night before.
Oh my goodness. I'm going to eat a little bit.
It's interesting that nobody's cats or dogs joined our meeting.
Wish my dog were here.
Are you in your office?
I am.
Oh,
I am. And I have these lights, 4 overhead lights. 3 of them are out. And so I brought my little light over to, so that I could at least look decent. You guys all look so good.
Do you think you'll have a cross-country season to coach this year?
Hey, Shane, I'm telling, this morning, I can't tell you what it was, but I heard some very good news that golf and cross country are going to get the okay.
Good.
At least those 2 are going to get the okay.
Cool.
The high school principal spilled the beans yesterday, so.
Who did?
The high school principal. spilled the beans
They
yesterday.
said that, and did he say that?
He said a few other things. I can't remember. I didn't pay
Yeah.
attention because I think I can say all this.
I mean, I would love to. I would love to hear that all the sports are going. I think football's is touch. I'd love to hear soccer going. There's a lot of kids that play, and I'd love to see them get the chance.
Mhm.
Yeah. They said they were going to make the announcement today.
I've been hanging on every word since March. It's been a total roller coaster. It's just literally on Saturday, I got some terrible news, and that suggested that it wasn't not even a possibility, and I just totally went into a funk. And then today I get good news. It's just been up and down the whole time.
Oh,
No easy answers.
No.
Yeah.
no, it's,
They'll probably be in school for 2 weeks. Somebody will sneeze, and they'll all come to a screeching halt. But
We'll see next week.
see you next week.
Okay, we're back to, recess time is over. We got everybody back. So Roger flipped the meeting around so the attorneys will do their presentation on their side, correct? We sort of roll back to the beginning.
Yeah. Well, I thought you should call it
Okay.
for the second appeal. You should call that the hearing to order.
Okay, so.
It's building permit 21004 if you're.
Okay. The Orono Board of Appeals is called back to order to consider the appeal of permit 21004. Correct?
Correct. And I would just, to facilitate things and to sort of complete the record, I would suggest a motion that the findings made in connection with the appeal of building permit 20-98, including the quorum, the record on appeal, jurisdiction, and standing to the extent they're applicable, be incorporated by reference into this appeal. Anybody want to make that motion?
So moved.
Second,
Who seconded it?
Gary.
I did.
Mary. All right. I would note that William DeVoe is not here and has withdrawn himself from this appeal. Vote on the motion, Shane Martin.
Yes.
Gary Noyes.
Yes.
Paula Moore.
yes.
Paul Smith.
Yes.
Mary Cathcart.
You're muted, Mary.
yes.
Jennifer.
Yes.
Okay, why don't we just go right into it? Attorney Foster, you're the appellant.
I'm sure. Just as a preliminary procedural matter, there are a number of neighbors from the road who would like to have an opportunity to speak during the public hearing. And forgive me, I didn't think about it in the last public hearing. But if during this public hearing there are any kind of general comments, would they be allowed to? They're not represented by my office. They're just members of the public. How do you want to handle that?
Are they offering testimony that's relevant and pertinent?
I don't know what they intend to say. They just have asked if they can have an opportunity to be heard, and as this is a public hearing, I think that they are entitled to speak if they would like. And I mean, it's not like they're arguing for our position or whatever. I mean, we're not presenting them as part of our presentation. They're just because of the way the format is set up, they just wanted to ask when they could be heard.
Okay. Well, I will say this, it's a hearing and it's public, but it's not necessarily a public hearing. I mean, they are.
Okay, I understand. If they have questions about the application or any of the testimony and speak, how do they?
It is not my call. Why is that happening? It's not my call. It's the chair, but I would offer the advice to the chair that to the extent what they have to offer is relevant and pertinent and not overly duplicitous is not the word, or is it?
Repetitious.
Repetitious. Thank you. That if there's time that they should be permitted to speak, but that's the call for the chair to make.
I think it's reasonable to allow them to speak. We just have to be, I don't know if there's any particular guidance of, let's say, at most a couple of minutes, or, I'm just afraid of somebody standing up and speaking for 10 minutes. That's the only concern, is that just, fairly, whatever number of people wish to speak, give them an amount of time, but relatively short. Thoughts from the board?
I agree with what the chairman said, that since we've spent a long time on the first hearing and it is getting later, then if they can be very brief, a couple of minutes. And, that's what always happens in hearings, that the public speaks and they don't think that they are being duplicative of what the previous people said. But anyway, yeah, I don't want to send people away and not feel like they've had a chance to be heard. Thank you.
Yeah, and I absolutely don't. Chair's instincts are spot on. Attorney Foster, why don't you go first, and then Attorney Lyons, and then that'll give everybody that's on the call an opportunity to sort of understand what the context in the appeal, so that their comments can be sort of tailored to be relevant.
Understood. Okay. We will begin our presentation, and I would just ask that when you, or however you would determine if someone has raised their hand or something, it wasn't clear to me when I was outside of this how you could kind of like flag that you want to talk unless someone inside had called on you. So I think that's the confusion from their perspective.
Well, we're going to have to ask the person behind the pretty building. There she comes. Sophie, are you still on? Well, let's get going. Oh. Hi, Sophie.
Hi, how are you?
I'm fine. You?
Just great, thanks.
I know that's coffee. Do you know? Did you hear the question?
I did. And Dave Mylan raised his hand, which flagged for me that he wanted to talk. And then I can change the chat feature. I'll just change the chat feature right now so that they can. Yeah. So at this point, they can chat with panelists. If people do that, it's gonna, and it gets too cumbersome for the chair, then we can turn that feature back off.
Okay.
Okay.
Well, then let's start with Attorney Foster, then we'll go to Attorney Lyons, and then we'll invite those who would like to speak to say a few words.
Okay. As a threshold issue with regard to these back lots, I think that there needs to be a common understanding of whether or not there's a portion of these back lots that are in fact in the shoreland zone. You have seen as part of the exhibits to appeal memo submitted by Attorney Lyons on behalf of the Spreckers, it's page 26 of 44, a site plan for the parking area on Pushaw Lake. In the argument submitted by Attorney Lyons, he says that the Spreckers measured to ensure that the parking area they developed was outside of the 250 feet. We would have argued that that is false and misleading, and that there is no clear evidence of where the starting point was from which they measured this 250 feet. If you look at this map, this is the one that I'm referring to. I don't know which exhibit number it is, but you can see that where the arrow begins along the Watts property, there's a hand-drawn watermark. Mr. Sprecher has added in the watermark himself. That's not compelling or credible evidence of where the high water line is on that shoreline, or a credible starting point from which to establish that the shoreland zone has started or ended. It's not clear to me what's inside the shoreland zone. But trusting that maybe he did try to measure 250 feet, I took a sticky note and measured from using his line measure from the shoreline that's actually delineated on this plan from the surveyor. And what I found was that it puts the shoreland zone smack dab in the middle of this 90 by 90 parking area, essentially. So there's some suggestion that this site plan is not accurate and that it is in fact misleading in terms of the realities of what's happening on this property. This is highly concerning for a couple reasons. One, because the shoreland zoning provisions that apply to the front lot will also apply to the back lot when we're talking about filling. When it comes to filling gravel into the back lot, for which Mr. Sprecher has requested to fill 98 cubic yards of gravel, he's required to, again, submit an erosion and sedimentation control plan for the portions of the lot and the parking area that are in the shoreland zone. It has not been established for our consumption which portions really are or are not in the shoreland zone. It's very concerning that there could be some aspects of this that are in the shoreland zone and that has not been complied with. Further, to develop a parking area in the shoreland zone, the Town of Orono land use ordinance requires that you get planning board approval. What the ordinance requires is that prior to getting a permit from the code enforcement officer for the areas that are outside of the shoreland zone, that you first go and get your planning board permit, and that you then go back and get your code enforcement officer permit for the back area. So this whole parking area is not in the shoreland zone, but there certainly are portions of the front of it where they are in the shoreland zone. And there are aspects of this site plan that are faulty in terms of the representations that have been made. So that's the first concern that we have here. Additionally, it's concerning that in the CEO timeline that was submitted as part of this, it's in the record on appeal package that was submitted to Roger, there's a page that says pre-filed argument and evidence of Town of Orono code enforcement officer. And on the second page of permit timeline for 163 Gould Road, he writes, note, after an appeal was filed, the CEO reviewed the application and found language that he'd overlooked during the original review. The application states that the Spreckers were applying to add 98 cubic yards of gravel to level a newly created parking area across the road from our home. During his visit, he was led to believe it was an existing parking lot, and at no time did anyone mention that it was newly created. So we can see here that there's a suggestion in the application materials and confusion about whether this parking area was newly created or whether it was existing at the time the fill was requested to be added. To be clear, the application does not ask to develop a parking area. It asks to add 98 cubic yards of fill to a parking area. There are representations made in the memo submitted by Attorney Lyons on behalf of the Spreckers that they acknowledge that they cleared trees to create a new parking area, for which we do not think that there is adequate evidence to establish that the permitting procedure has properly been followed, or that there is enough here to establish that the provisions of the shoreline zoning ordinance have been complied with. My last point is about the clear cutting of this portion of the lot. The shoreline zoning ordinance does have provisions that require that prior to clear cutting in any manner that it be in connection with a permitted use. So if Mr. Sprecher were to have received a permit for a parking area, it would have been reasonable that he could have removed some trees. That probably would have been part of the analysis. But because a parking area was not permitted here, the clear cutting of the lot and the portions that are in the shoreland zone need to be subject to the shoreland zoning ordinance provisions regarding removal of trees. There's no evidence in the record that there was any thought given or analysis or review of the clearing of this parcel within the provisions of the shoreland zoning ordinance, mostly because the CEO did not know that this wasn't already a parking area when he issued this permit. So these are some highly concerning matters. It's not an enforcement matter. It's just a matter of the permit being submitted and what was done in, once again, in preparation for and establishment of the pre-existing standards on the site. And I think that the Watts would again like to speak about their observations of, sorry, there's a motorcycle, the activity that was occurring on the site.
Yes, thank you. First of all, I'd like to address the question of whether the shoreline 250-foot limitation is included in part of those lots. I think if the board looks at the survey, the actual survey that the Spreckers had performed, you will see that the length of their lot for where the house is 122 feet. If you take the same measurement of that and add it to the back of the house, another 122 feet will take you to 250 feet, and that will be clearly, at least partially, within those back lots. So I don't think that's an issue at all. At least portion of that property is within the 250 feet. And I will tell you that in May, again, when I was opening up the house, they were doing a lot of work cutting down trees, which was a highly wooded lot back there, very dense. Couldn't see through the trees hardly at all. Can't see the forest through the trees. But they were clearing it, and as board member Moore was saying, it was during COVID. I wanted to talk to the town about that to see if is this something they can do. Can they just clear the lot? But town hall was closed, and I didn't get a message, and then I went back to Florida. But they did an extensive clearing in May. It continued through June with large tractors, backhoes. They moved boulders the size of
a desk.
The size of a desk. Good analogy. And they dug up the tree roots. In their submission, they said that they cut down 12 trees. In the photographs, you will see a long length of cut wood. I would estimate well over 50 feet long, about 4 or 5 feet tall, and the logs are about 3-4 foot long. It sure seems like a lot more than 12 trees. This continued extensively throughout, and then leveled the lot, moved dirt throughout May and June. And then when I left back on July 5th, I was there again at the end of June, early July. By that time, it was pretty much cleared. It's my understanding that they did not apply for the permit until July 8th. So all of this work was done before the permit was applied for. And those are my observations. And again, If you look at that survey, it's clearly within, portion of it is clearly within the 250 feet. And again, it's the erosion control that's lacking that we were also concerned about back there as well.
Just for context, I would direct you all, excuse me, to exhibits F through F7, which in some of the photographs, you can see the stumps that were present. You can see the extent of the parking area that was cleared. You can see where the trees were removed. You can see in some of the photos just how many vehicles are being parked there. Attorney Lyons mentioned in the prior presentation that Ms. Fitzgerald has put up fencing along the property line, or he allegedly said on the structure property. So in one of these photos, you can see some of that fencing. So you can see where the property line begins, and you can plainly see that the cars are parked right along the property line in exhibit F, F1, and F2. So the assertion that the parking area has been developed outside of the shoreline zone is misleading.
Katie, do you want to, or are you, do you want to address the issue of right title or interest? Or is that no longer?
I think it's necessary for this. I mean, I'm trying not to confuse these issues and make them overly complicated. I think that we are handling the issue of right title and interest in the litigation that's before the court. And as I have tried to establish with Attorney Lyons, I would prefer not to talk about the extensive litigation, and I don't believe that it's relevant to whether or not the permits here have been complied with. I think it's kind of a cursory matter. I mean, the question of whether or not they actually have access to their backlots and whether they're trespassing on Rosemary's property every time they go back there, that's part of this litigation, and we have coordinated in our office to take care of that in the court system. So I would just put it to rest for now.
Okay, fair enough. Mr. Lyons?
Yes, thank you. I'm going to do the share screen function again. So again, we're talking about the back lots, and what's important to note is that your ordinance defines the shoreline zone as anything beyond 250 feet horizontal distance from the normal high water line of any great pond, that being Pushaw Lake. So your shoreline zoning ordinance is not applicable beyond anything 250 feet from the lake. One, I just want to address, Attorney Foster noted the comments in the CEO's report regarding whether or not this was, he was led to believe this was a existing versus new lot. Joe and Mindy were never told anyone that this was an existing lot. They were very upfront about the fact that they had cleared these trees. They said in their application to the code enforcement officer, this is for a newly created parking area. So I don't understand, I don't know what was lost in translation, if there's any confusion in conversations with the code enforcement officer, but I just want to make clear for the board that Joe and Mindy never asserted that they were clearing, that this was a previous existing area. And they were very upfront about that they did cut trees. But again, beyond the 250 feet of the lake, you're permitted to do so. And that is located in the forest and agriculture zone. And as your ordinance points out, within harvesting and removal of trees within the zone doesn't require any approvals. And moreover, the parking area is a permitted use within the forest and agriculture zone. And just for clarification for the board, the lot coverage standards for the forest and agriculture zone are no more than 33% lot coverage. Here, the 99 by 90 parking area is approximately 8,100 square feet, which is 11% of the total area of the back lot. So more than satisfying that requirement. I know we've talked about the erosion and sedimentation control plan. Joe and Mindy are in possession of that BMP. That you can download it off the internet. And the plan says erosion control measures must be in place before, during, and after such work is done. That's all. The plan requires it. They have the BMP. They followed it. You can see from the pictures. It's a simple gravel parking area, and it's for a single family residence. 98 cubic yards of gravel was spread on a recently cleared area, and they park their cars. They park, they're a big family. They have a couple cars, they have a boat, they have a snowmobile and a trailer. As I noted from the previous hearing, their front lot is not large, and there's not a whole lot of room for parking. The abutters take issue with them parking near their home and the impacts that allegedly is having to their property. So Joe and Mindy, needed to find a place to park their cars. They have this, large parcel of property. It's within their right to build a parking area and to move their products their possessions there, their trucks, their snowmobiles. I mean, this is rural Maine. This is a lake in rural Maine. These are possessions they're entitled to have, and they're entitled to keep on their property. I will note that in the record, it shows that there was an email exchange between the CEO and the Public Works Director, Rob Yurza. I'm probably pronouncing that wrong, which sought his opinion on whether this was sufficient. The Code Enforcement Officer Murphy's filing, he says that yes, he found the spreading of this gravel to be permissible and filed no objections. There was a picture associated with that. We've provided an updated picture as a site plan to show the parking area and its relationship to the parcels in the lake, and that's provided here. There's also argument, it was in their initial filing. I did not see it in their subsequent filing to the board, but whether or not this is off-street parking or loading under your ordinance. If you review that section of your ordinance, that's only applicable to commercial uses or in some instances, residential properties abutting public ways. And here we're on a dirt road that is a private right-of-way. And so for a single family. So any of these alleged, asserting that, commercial standards apply to them clearing this area to park their cars is not supported by the ordinance. And it also doesn't make sense. If there's any actual concerns about maneuverability or safety, the pictures are clear. You can see that there's plenty of room for a car to turn around, to enter and exit safely, and to maneuver on the parking lot. As far as whether, even if part of this parking lot is within the 250 foot shoreline zoning area, this type of work is permitted. The clearing of trees and vegetation is allowed for permitted use, so long as it's not 25% of the lot area or 10,000 square feet, whichever is greater. Here, even if the entirety of the parking area was in the shoreline zone, it falls short of those maximum thresholds. So one, this was a permitted use, which I'll discuss, and two, the amount of clearing that was done, even if it was entirely in the shoreline zone, would be permitted. Now, the permitted use in the shoreline zone is filling and earth moving of greater than 10 cubic yards, and that CEO can issue a permit for that. This gravel parking area for a single family home is not a commercial use such as a parking facility or a parking area as is defined in your shoreline zoning ordinance. And so, you can take a look at that section of the ordinance, but you can look at the specific language when they refer to a parking facility or here a parking area. They use language such as parking areas serving boat launch facilities, public boat launching facilities. And then the typical parking space requirement, approximately 10 feet wide and 20 feet long, except for parking spaces for a vehicle and boat trailer, shall be 40 feet long. Internal travel aisles approximately 20 feet wide. These are all standards that are clearly for a parking lot serving a commercial purpose, such as a boat launch. Think about it this other way. So to construct a single family home in the shoreline zone or to construct a carport or a garage, which is an accessory structure, you only need CEO approval. But to construct but the arguments of Attorney Foster is that if you construct a gravel area to park cars for a single family home, you'd have to go for planning board approval, then come back for code enforcement approval. Whereas to build an entire home, including a driveway to that home, or to build a garage, you would only need CEO approval. I mean, Joe and Minnie eventually hope to build a garage on this site. This was their first step. Again, relieving pressure from the neighbors as far as where they're putting their cars near their house. So, they can come back and seek a permit for a garage, which is permitted under your ordinance for both the shoreline zone and outside the shoreline zone. And we've already discussed, we don't need to discuss the pending lawsuit, so we won't go there. And I'll just remind the board that it's the applicant's burden, the appellant's burden here to prove to you that the permit was issued in error and that there's sufficient evidence. Again, you're not limited to what the code enforcement officer was reviewed. You have an entire record here, including the code enforcement officer's files. All of that is before you, and you can use everything that's been put before you to make a determination of whether this permit was issued correctly. Thank you.
Patrick, can I ask a question? Mr.
Yes.
Chair? Is that okay?
Yep.
Did you say that the parking area, or whatever we're calling it, is a permitted use in the shoreline zone? And if so, how would you characterize that? What would you call that use?
This is an accessory use to the primary use of the property, which is a single family residence. You're allowed to have an accessory. You're allowed to have the fill of cubic, bring in fill for greater than 10 yards. That's a CEO permit. And two, for accessory structures, such as that would be like a garage, you're allowed to have that with code enforcement officer approval. So here, building a parking area that's similar size to a garage this is an accessory use to permitted structure, which is a single family home.
I guess I would suggest that Attorney Foster, if there's any cross-examination that would like to proceed, this is probably the best time to do it.
Yeah. Our attorney line client planning to offer comments, or do you just want me to offer some response to the comments that he made?
You can offer a response to my comments. My clients aren't planning on making any further comments.
Okay. Attorney Lyons has suggested during his comments that this is an accessory use which can have code enforcement officer approval. I think that what is clear from the record is that the code enforcement officer did not believe that he was permitting this accessory use. He has said in multiple comments that he did not know that he was permitting a parking area or that there was a newly created parking area established. In his timeline, he even says, during the conversation with the applicant, they led the CEO to believe that the parking area was an existing parking lot and they were simply doing maintenance on it. At no time did they mention they were creating or expanding a parking lot. The CEO emailed Rob Yerza, however you say it, with the proposed work, as the ordinance requires permits be approved by him as well as the CEO. I mean, he's in no way saying that he thought that he was approving a parking area. Additionally, the original appeal suggestions that we had made that the off-street parking provisions could be applicable was because there was absolutely no information in the record about how the Spretchers intended to develop this parking area. The site plan is only an additional submission since this appeal was filed. And as I've stated, it seems plain that they're still applying for a parking area. Parking facilities in the shoreline zoning ordinance require planning board approval. Just because they're now changing the terminology from which they originally applied so that they can avoid planning board approval doesn't mean that the application and the record before you established that they were entitled to do the things that they had done. And that's an enforcement issue, so that's not for your consideration tonight, but the record does not establish what was intended. Originally, it was a parking facility. Now it's an accessory use. The clearing was in connection with a permitted use. There's no information in the record that the code enforcement officer approved an accessory use for those back lots. There's no information to back up what's being put forth. Additionally, the suggestion that this is, at the beginning, it was outside the shoreline zone. Now it may be inside the shoreline zone, but the requirements aren't applicable. It just seems like there's a lot of misdirection happening here in order to avoid the applicable provisions of the land use ordinance and the shoreline zoning ordinance.
Roger, can I respond?
Please, I would ask the chair, but yeah.
Chairman Martin, may I respond?
Yes.
Thank you. Just two things to note. The application to the code enforcement officer says for new parking area. So there's nothing, the fact, there's ample evidence right there on the written document that Joe and Mindy were totally forthright with this code enforcement officer saying this is for a parking area. The permitted use is both in for the board's determination whether this is permitted use. It's a permitted use two ways. One, you're allowed to, the fill that is allowed to be brought in and spread on the area over 10 cubic yards is a permitted use from the code enforcement officer. And in addition, an accessory use to a primary structure and use such as a single family home is also permitted with code enforcement approval. So I just wanted to clarify those 2 points.
Could you repeat that last point, Patrick?
Sure. So there's 2 ways that this is a permitted use within the shoreline zone and beyond the shoreline zone. For the beyond the shoreline zone, accessory uses and structures are permitted uses, as is fill. And within the shoreline zone, the CEO can give approval for bringing in gravel greater than 10 cubic yards and can give approval to an accessory use to a primary structure such as a single family home. And that's what's happened here. To assert that parking area requirements, they're designed for commercial marinas and boat launches apply to a single family home gravel parking area just falls flat when you read the language in that ordinance. So thank you.
Just to be clear, we're not suggesting that those requirements apply. They were brought up as a means of establishing that we did not have enough evidence before us to establish if those requirements applied. There was not enough information about what this newly developed parking facility in the permit application was. There was no site plan originally submitted. We didn't know. We didn't understand what area was there. So those arguments were raised in response to a lack of information about what was intended for those back lots. Additionally, Attorney Lyons continues to insist that accessory uses are permitted with CEO approval. In this instance, the CEO has not given approval for an accessory use. He's given approval for a parking area. And he's given approval in his own words, to add fill, and he did not think that he was permitting a new parking area. Those are his words. Those are not my words.
But we're not dealing with what the code officer did, are we?
No, we aren't. The code enforcement officer's timeline is part of the record on appeal package that you submitted. So I believe that it's relevant information when determining what information is available to this board in determining whether the permits have been complied with and whether there's record evidence to support the issuance of this permit.
Okay, I have a question for Roger. In this packet that we got, it's pretty clear the appeal documents I've found the permits issued, but where in this packet is the application for the permit we're discussing right now? I've been flipping through the papers and haven't found this application yet. Where is it?
Parties want to speak up?
If you look in the Watts appeal, Member Martin, they're at the back of the originally submitted Watts appeal, if you have a copy of that, the application, the land and building permit application is behind the permit that was issued for to add 98 cubic yards of gravel to parking area across from 163 Gould Road.
Also Exhibit I to the Joe and Mindy's filing. It has both the permits that were issued and the applications that were submitted for the permits. That's page 20 of our exhibits.
Okay, that must be a failure on that. Okay, I'll go look for that.
If you're looking at the numbering at the top of the submission by Attorney Lyons, it's actually page 24 of 44. It's just page 20 of the exhibits. So if you're just going to look at the top right corner numbering, it's 24 of 44 is what you're looking for.
Yeah, that one may be my bad on my printing because it was very difficult to print that document and I may have not printed those pages. I'll look for it in the Watts appeal.
Roger, would now be a good time for some of the neighbors to speak kind of generally, or do we want to keep on these issues?
I would like the parties to be satisfied that they've examined each other as much as they need to. Then I thought we'd go in and invite the others. And then if you both want to close out, that would be, we'll give you that opportunity. So if you two are set, we can go right into the others.
I'm all set.
Okay.
I would think that Colleen, Rosemary's daughter, would like to speak first.
Colleen,
You're on mute.
You're on mute.
Oh, hello. Can you hear me?
Yeah.
I'm Rosemary's daughter. My name is Colleen Fitzgerald. And I can't tell you how upset I was when I read Attorney Lyons' filing that he and the Spreckers filed and made claims about my mother that are completely untrue. They have no place in this hearing, but as Attorney Lyons has introduced them, I would really like to address the specific misrepresentations and falsehoods regarding my mom that the Spreckers and Attorney Lyons included in the public record. I have a long statement written, but I know you don't want to hear the whole thing, so I will try to abbreviate it as much as possible. The first misrepresentation is simply that my mother's fence blocks the Spreckers' access to their back lots. We've shown that the Spreckers have been able to clear cut their trees, do extensive land moving, dump loads of gravel, place their large collection of vehicles, boats, trailers, construction equipment, playhouse, and a couple of wood sheds. It's simply not true. There is no part of the Spreckers' back lots that they have not been able to access since 2019, despite the fact that they have no legal right-of-way yet. This is very easily demonstrated with photographs. The second falsehood contained in the filing was that when the Spreckers delivered their letter to my mother, she responded by calling the police. This is outrageous in that it's so easily disproven. It was in fact the Spreckers who informed the police of their intentions to tear down my mom's fence and provided the police with a copy of their letter. I have a photograph of that letter where right below the signature line, the Spreckers wrote, Orono PD know of this, have given them a letter. I can email that by tomorrow morning. My mother responded when she received that letter on July 6th by calling her lawyer and sharing it with him so that he could respond to the Spreckers' claims and demands in a legal, responsible, and impersonal way, allowing her to avoid any and all direct contact with them. This is easily proven as a misrepresentation at best. There was a accusation that she accused the Spreckers of stealing her trees. She had a forester come out to look at her property in 2019 and confirmed that some small trees and branches on her property near the Spreckers' home and on my mother's shore lot had been recently cut. The forester said, "You have the right to be reimbursed by the people who cut these." No one else was around but the Sprecker except for the Spreckers or their agents. She told the Spreckers about this, but she never pursued it. She didn't want any further interaction or trouble with them. Another false statement that my mother said, when the Spreckers walk out of their house, I own them. This is, again, untrue and misleading. I believe what this stems from is when the Spreckers surveyor was discussing property lines with my mom at his request. My mom said, when the Spreckers walk out of their house onto Gould Road, which runs very close to their front door, they are on my property. Someone could have misheard that they are my property. They are on my property. I have no idea. They make so many bizarre and false claims against my mom. But my mom owns that road and pays taxes on it and was asked by the surveyor to discuss the property lines. Next misrepresentation, that my mom takes pictures of the Spreckers and their home. This is untrue and very misleading. My mom has taken pictures of her own land. When the Spreckers' vehicles, their guests' vehicles, their contractors' vehicles, their trailers, their boats, their equipment, their woodshed, their mailbox, their planters are illegally parked or placed on my mom's land. She's done this to use as visual evidence of the Spreckers' continuous and ongoing trespass. She's never approached or harassed the Spreckers, never. To the contrary, she has gone to great lengths to avoid all contact with them, even as they pursued further contact with her, and hasn't even spoken to them since May 2019. She only ever had contact with the Spreckers' guests or contractors who Attorney Lyons has claimed she harassed during the summer of 2019 to politely inform them that they were trespassing on private property when they parked on her boathouse driveway. She was forced to put up no trespassing signs up on her own private land in an effort to discourage all of the Spreckers' many visitors and contractors from continuing to park on her boathouse driveway. In one instance, one of the Spreckers' contractors set up a saw and was cutting lumber on her driveway. I actually witnessed that one myself. I would like to close by saying that my mom has always been friendly with all of her neighbors, past and present. She loves people and has never had a dispute with anyone. As a lifelong member of the Gould Road community, she has earned a reputation of being kind, fair, and a generous neighbor. The fact that she has been so grossly misrepresented by the Spreckers and their attorneys is an absolute travesty that her family and friends are struggling to understand. I'm baffled. Why have these misrepresentations been presented to this board when they could be so easily disproven? I can't imagine what agenda this could possibly further other than to color your opinion of my mom and undermine the merits of her appeal. And this is the last thing I wanted to do. My mom wouldn't have brought any of this up. I would never have brought any of this up. But Attorney Lyons put it into the public record and painted a picture of my mother that is so far from reality. It's shameful. And that's all I have to say. And I'd be happy to submit the picture of the Sprecker's handwritten note about them informing the police. And that's all. Thank you.
Thanks, Colleen. If there are no other comments, I think that the Morans, who are within 500 feet of the property, would also like to possibly ask questions or make a comment. Are they here? Oh yeah, there they are.
Susan, you're on mute.
Can we unmute her?
Sophie, do you have the ability to unmute Susan?
The Watts have said that they can't see her in this. So I don't know if there's some technological problem with having added her back. We have a screen here with no sound and she's not on that either. Just on my computer, I'm also a participant in this.
Do you see her video? I just see her name.
No, I'm saying that other participants can't see her at all on the screen. They can only see the 9 of us.
Do you have others that might like to speak?
I'm not sure. If anyone else on the call would like to speak, maybe raise your hand and indicate to Sophie that you would like an opportunity to speak. Someone with the last name Hodgson or Hoskins would also like to speak. Maybe we could bring them in and then try to bring Susan back.
So Susan is frozen. I think Susan needs to disconnect and then come back in and we can try it again, but I can't move her anywhere.
Oh, she left. Okay. You're on mute, Mr. Hodgson.
Okay, you hear me now?
We heard you for a second. You went back on mute.
Hold it down. How's that?
How's that?
Don't touch anything else. Perfect.
Okay, I won't touch. I guess the first question I have is in the town of Orono, is it customary to do the work, then get the permit? Is this normal operating procedure? And the other question is, and I direct this to the board, how many single-family homes do you know of that have a 20-car parking lot? I'm done.
Okay.
Some sort of possible commercial. Am I there?
You went in and out.
You went in and out, but I think we got the gist of your comments.
Thank you.
Katie, can you see anyone else?
I can't see anyone at all. I'm just passing along messages from the Watts. People are contacting them and asking for an opportunity to speak. So just making sure we give everyone that they know a chance. But if Sophie doesn't see anyone else, maybe Susan wasn't able to get back on.
She is not as an attendee, and I don't see any other hands.
Okay.
Okay.
Mr. Chair, I would invite the parties to make very brief closing arguments, then probably move to close the hearing and move to deliberations.
Agreed. Ms. Foster?
Sure. I think that we find ourselves in a very similar position to where we were before in terms of a lack of information from which we can make a determination about what is being permitted here and what the applicant is in fact applying for. I think that the application reflects that they're applying for a parking facility, a new parking area. You've heard comments from Attorney Lyons that it's actually for an accessory use. It's not clear that that was outlined in the application that was submitted or that that was established in the record evidence that you have before you tonight. If this is in fact a parking area, as we have been led to believe through some of the submissions, including Mr. Spetcher's own site plan that says parking area on it, we can establish that it is likely subject to the parking facility requirements and the land use standards of the shoreline zoning ordinance, which would require that for the first portion of the area where there's been parking, that he receive planning board approval for that use. It is challenging in this instance to determine the extent of the review that may be required because there's not a lot of information about how many parking spots he intends to utilize on this lot or how he intends to size those parking spots. As you've heard from many parties, Mr. Hodgson suggested that there could be as many as 10 to 20 parking spots. We don't know. We simply don't know. Additionally, for the portions of this area that are in the shoreland zone, they're still subject to erosion and sedimentation control measures for the filling that has occurred on this parcel. Yes, filling is a permitted use, but they do need to submit the erosion and sedimentation control measures. It's not sufficient to just say that we are aware that maybe these homeowners have the erosion and sedimentation control handbook. It's not evident from the record that's before you that there was any conversation about how erosion applies to the back lots. Additionally, the clear cutting is very concerning to the neighbors. This was a densely wooded area, and there's been no established record that shows why they're clear cutting this area or what they're intending to do here. They can clear cut portions of the shoreland zone in connection with the permitted use. If there is an accessory use permitted, that's one thing, but in this instance, there has not been an accessory use permitted.
I think the record before the board now makes clear that this area is intended for parking. The Spreckers also use it to play Frisbee with their children and have them drive the remote control cars around. But what is before the board is that there is evidence that this board could uphold the permit for any number of reasons. One, it being an accessory use to a principal use and structure, which is a single family home. There's also record that shows in this that the board can approve, this code enforcement officer can approve the spraying of gravel. So there's ample evidence and reason for this board to determine that that the permit was issued correctly for these types of uses. Trying to argue that if a family wants to clear an area, and they do intend to eventually build a garage there, to clear an area to park, residential cars, and again, a boat and other snowmobiles associated with a single family residence, to now assert that you have to go to planning board approval to do that, but you can just get a code enforcement officer's approval to build a garage in the same space. It just doesn't make sense. And it shows that the parking area standards in the shoreline zoning ordinance are not intended to apply to the Sprecher's, single family residence parking area. And so with that, there's ample, again, the burden's on the appellant to prove the application was issued in error, and that there's ample evidence before this board that the Sprechers can have a parking area, clear trees to do it, and to spread gravel on it. Thank you.
Mr. Chair, all yours.
So close the public hearing. Is that where we're headed next?
I think that's next.
Okay. I offer a motion to close the public hearing. Is there a second?
Second.
All those in favor? Oh, do you have to poll this, Roger, or?
No, I think you have the authority to simply close it on your own without a motion.
The public hearing is closed. And we shall open it for discussion with the board.
Mr. Chairman, I have a procedural question, and maybe we could seek guidance from Roger on this, if I may.
Go for it.
Is it permissible in the board's deliberations for the board itself to introduce into the record a relevant section of the land use code that is relevant to the question before us, or if it's not been put in there by either appellant or the applicant, is that off limit?
No, it's permissible because that's the governing document by which we operate. Typically, people have the land use documents in front of us and we flip through them during the meetings. So cite it in your discussion.
So just so I can understand this a little bit better, they have a parking area. Some of it's in shoreland zoning, some of it's in forest and agriculture. And with forest and agriculture, the CEO can give permission for it. But if it's in shoreland, they have to go to the planning board. And if so, what part of the parking lot is where?
Right. And I did find their permit, and it clearly says that they were going to add 98 cubic yards of gravel to a parking area across from the 163 Gould Road. And it was approved by Bill. So why didn't Bill say you need to get this from the planning board? And the form is very, it's like one size does not fit all. So it doesn't provide with very much information. It does say, however, that erosion control measures must be in place before and after all earth moving, etc. And it says all work must be done according to application and plans as submitted. So attached to this, there was not a plan. This was one of the documents that Roger sent. So I'm totally confused.
Well, I took the documents Roger sent and put them, I have them on a thumb drive, and I did bring it up. And part of the as previously mentioned by Mr. Lyons, in the packet that we got from him on his labeled pages 24, 25, and 26. And that's his labeling inside the document, not necessarily where it would appear in a PDF. includes the original application for what became permit 21004. That is in material we got. And on page, what is it, 20, his titled page number 24 of 44 in paragraph, let's see, D, says proposed use. And then it's in the application, it says add 98 yards gravel, parenthesis 7 times 14 yard truckloads, in parenthesis, to level newly created parking area across Gould Road from our home. So in the application, that is what the Spreckers said.
Mr. Chairman?
Yep.
To focus this discussion, I would like to move that this gives me no pleasure, that the appellants have demonstrated that this permit was issued by the code enforcement officer in error.
Second. Is there a second to
Second.
motion? There is a second.
Mr. Chairman,
We'll open debate on the motion.
if I may,
Smith?
maker of the motion, may I put some thoughts before us here. First of all, I want to be sure that our deliberations are focused on the permit to add 98 cubic yards of gravel to a surface. It is not whether or not this is a conforming use, the parking area, or that the trees were cleared or not cleared. What is before us is a permit to add 98 cubic yards of gravel to a piece of land. The site plan presented with the code application we have been presented, I find convincing evidence that site plan does not clearly delineate the boundary of the LR district of the Shoreland Zoning Board. The evidence that they've shown that there is a provision regarding parking lots and non-vegetated surfaces in the Shoreland Code, section 18274, 2 in parentheses D. Within the LR district, parking lots and non-vegetated surfaces shall not exceed 20% of lot or a portion thereof located within the shoreland zone. So the question before us is, there is some portion of that 90-foot by 90-foot parking area for which a permit was granted to apply gravel to it. There's some portion of that parking area that it is suggested lies within the LR zone. And if that be the case, then that portion of the parking lot can be covered only to the extent of 20% of the area. And I don't think we can determine whether it does or doesn't, but the site plan that was presented in support of this permit does not adequately delineate either the boundary of the LR district on that lot nor does it address how much of the 98 cubic yards of gravel was applied to the lot portion that lies within the shoreland zoning district. And so, again, I say it gives me no pleasure to make the motion and defend it, but I don't see how we could uphold granting this permit with those open questions.
Once again, like previously, I find information lacking that I would need personally to make a decision. So as far as I'm concerned, we have an incomplete record, and in which case we have to find for the appellant that they have met their burden of proof. The code enforcement officer issued the permit in error because not all information that's needed was there.
I agree with what Gary said, and it seems to me that if a portion of that parking area is in shoreland zoning, then the code enforcement should have determined where that is, and it would be required under the ordinance, as I understand it then, if some of it's in shoreland zoning area, that it go to the planning board. And that didn't happen. Is that right? Am I correct about that?
Chairman, Mr. Chairman.
Yes, sir.
If I might just respond to Mary's observation here. The issue is not whether that portion of the parking lot, the issue before us was a permitted use, the parking lot. That's an enforcement issue if there is an issue there. The question before us is the permit for adding fill, adding gravel within what appears likely to be the shoreland zoning district.
Thank you, Shane.
I mean, living in the shoreland district myself, I'm very aware of that imaginary line as it varies along the property. So it seems unusual that, you know, a permit request like this, that you wouldn't have that squiggly line running that distance back from the property.
Mm-hmm.
Yeah. Hmm. So again, the record is not complete. I think that's what I'm hearing everybody saying.
I agree.
Just as a personal note, I drove out there the other day to look at it, drive by the area and look at it. And I was chased away before I could get a look at anything. So.
Well, it's a private road that we're not supposed to go down unless we have permission of one of the landowners as a guest.
I didn't have time to go and look at it, and I had my grandchildren here, and I was too busy this week to look, so I didn't know that. But
Yeah, it's a private road though, so that's
right. Yeah, I read that in the information we have.
Yeah.
Who chased you away?
One of the residents there, a gentleman.
Might we be approaching a voting time on this?
Jennifer, my head was down. Paula articulated that she thought the issue was a lack of information, building on what Member Smith, Noyes, and Martin have all said.
I have nothing further to add. I just
Somebody
agree
said,
with
I
it.
agree. Was that you?
Yes, that was me. I have nothing further to add to what was said. I agree to everything that was said.
So is there any other commentary by members of the board? Any questions we want to ask of any parties? Okay, I propose we take a vote. Mr. Huber, do you have any questions for members of the board so that you have enough information to write your piece on this?
No, I'm comfortable that I have, I understand what the consensus of the board is. I'll put it in writing, obviously, and you all will tell me how far off I was. But at this point, I think I have the, I think I have the information that I need.
Okay.
I will call for a vote then. Shane Martin.
I vote for the motion. I vote yes.
Gary Noyes.
Yes.
Paula Moore.
Yes.
Paul Smith.
Yes.
Mary Cathcart.
Yes.
Jennifer Jane.
Yes.
All right. The vote being 6-0, the motion carries. Okay, at this point, I will undertake to write a decision on both appeals. I will send each of you a draft of that separately, not together. I would strongly discourage you from discussing it with your fellow board members. I will send it to you separately, so there's no risk of hitting a reply all. Please offer your individual comments to me, and I will incorporate them into a draft. And then I will send out a completed draft to all of you, and we will meet again in this format. You will have those completed draft before you, and you can vote on the written decision for each of the two appeals. The decision, you've made a decision. The decision's not final until you issue that written until you issue that written decision. You have 35 days to issue a written decision. So we've got some time, but I will have the town work with you to schedule a time that works for all of you. It'll be the exact same format. In fact, it's simply a continuation of tonight's meeting. All the parties, everybody that's been here is entitled to watch you. I don't know that there will be any further deliberations. Hopefully it'll just be a function of looking over the draft that you have all reviewed individually, and see if we can get signatures from all of you on a final decision.
A procedural question. Okay, and this maybe you may have the facility to do this. Are we going to, okay, we'll vote and we'll say yes or no, confirm. Will we have to render a physical signature somewhere? Or do we have a mechanism for electronically signing?
That's a great question, Shane. I don't know if the governor's rules allow for electronic signature. My hunch is that they probably do. I promise you, I will make it as easy as possible and convenient. Sophie may know the answer.
Sophie's there.
She does this all the time.
Yeah, we're still using real signatures, and we probably would try to socially distance get signatures in a socially distanced way from individual board members after the vote.
Okay.
Basically, we'd stop by the town office at our convenience during hours and sign, correct?
Yeah, that is how it works. And if we have somebody that can't do that, we've got people who can drop them at your home on your doorstep, and you can let us know and we can pick them up.
Bring your own pen.
Does that approach make sense to everyone? It's certainly better than trying to put it to writing right now and write it while you guys all sit there and watch me.
Yes, great.
Good.
Sounds good.
All right. Party, I know you're still hanging on. Do you have any questions?
Nope.
Take that as a good sign.
Okay, I'd entertain a motion to adjourn the meeting to continue at a future date to be determined by Mr. Huber.
So moved.
Seconded.
Anyone opposed? Hearing none, motion carries.
Good night.
All right.
Good
Night,
night, everyone. Thank
Night,
you.
everyone.
Great.
Thank you.
You guys were awesome tonight. Well done.
Thank you, Roger.